Yeah. Party people, let me see you now. Throw your hands up, yeah. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me, yeah. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me, yeah. We got the yeah. Party people, let me see you now. Throw your hands up. We got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes, we're making the good times. We're taking over your mind and we're getting the good vibes. Now you're telling me don't stop the melody. Good times ahead of me. Yeah, we got the good rhymes.
Hello, everyone, and welcome to today's chat. Put a 1 in the chat if you can hear me, because I swear to God, if I'm muted again, I'm going to punch myself in the face. Hollywood, thank you for those jewels right off the top. I appreciate you with the sunshine. Hello to live crew. Hello, Plan B. Hello. Okay, you guys can hear me. Yay! We've done it. We've done it. Hooray. I've been able to start a stream, and we're doing all right. So, hello, everyone. Hello. Welcome to Tuesday, July 21st of 2026. So, what we're going to do today is we are going to try our best to speed run the rest of Michael Maricini, because if I got to read another thing about this goddamn case, okay, I need to move on to something else. My brain is starting to smooth over. I am now becoming baby no thoughts. With that being said, July 22nd is tomorrow, and let's see. Tomorrow, Lo will be discussing something with the judge at 8:45. There is a trial assignment, so we will have that. I got to tell you, I was on here for 6 hours yesterday. I was very exhausted. I had a great time. I hope you guys had a great time. And, you know, it's a good time to be alive. Anyways, with that being said, so we are going to try to get through Michael Maricini as fast as we can so we can then move on to the depths of whatever you guys want to move on to next. If you want to go into the depths and chronologically through Clayton, we can do that. If you want to move on to a bankruptcy thing, if you want to move on to whatever Volo has, we will do that. Good morning. I know it is starting to break me. Well, and you know what? It's not that she's starting to break me. It's not that. It's not the case. It's the redundancy of everything being said in these motions. But there are little tidbits that you get in the motions, that you don't get if you don't read them. So you got to read them. But then I feel like I'm reading the same thing over and over and over again. So I needed to just clear my brain. If you are in Plan B, leave me. Tell me what you're drinking today. What are you drinking while watching this? No judgment. I'm still trying to convince the bankruptcy court that minor perjury was just a dishonest mistake. Fletcher, I believe in you. I think that you could do that. If you are new here and you haven't subscribed already, please consider doing so. My name is Bacon Bearzz. The show is called That's My Opinion. I'm a live streamer now. That's just what I do. I go live basically every day. I'll have more long form videos coming for you. I've decided I'm going to do vlogs for members. I think that'll be fun. My life is very boring, but I want to talk to you guys behind the scenes. And then, just a lot more stuff coming in August because my kids will be going back to school and I will have more time. So if you can, go under the video, hit the thumbs up, do all the YouTube stuff, hype, like, subscribe, mash your face against the keyboard, do whatever it takes. Do whatever it takes. We are on the road to 18K, guys. It's crazy. We're doing it. And I am surprised. Hi, Corgi Mom. All right. With that being said, let's get into it. Let's start one off the top because everybody always asks. So we'll start one off the top because that's what we do.
We tell Laura to go to trial, Laura Owens.
Do it. We believe you. Tell your story. God damn it. Go to trial. You're not a liar. We believe you. Do it. Hey, Laura Owens, go to trial. We believe you. Everybody else is lying. Go to trial. Laura Owens, we can do it. We believe you. Pelvic thrust. All right, we got that going. Let's see. All right, so today we're starting off with the fact that surprise, Laura Owens. Laura, are you here today?
I am. Hi. It's after 7 a.m., so I decided to show up for all you pores in the chat. Ugh. Oh my God. Wait.
Did you guys see my thing in the Discord? I put a TikTok in the Discord. I'm just going to show it to you right now because it's so goddamn funny. If you were on the stream yesterday, it was just so funny and it made me laugh. She's not like other girls. High kick finale. I love it. Let me show you guys this TikTok that I found this morning. I was putting my makeup on and I was crying because I was laughing so hard. Let's see. Where is it? It's this. So this is my Discord. This is what I showed everybody in the Discord. This is literally Laura Owens whenever she sees somebody in the ATM line. So, oh no, where is it? Wait, no, you got to start at the beginning. Why does it do this to me? No, wait. She's homeless. I just, as soon as I saw this, I'm like, that's Low driving through the ATM. I feel bad for them, but they're homeless. They're homeless. He was literally
Doing heroin, and I couldn't take any money out of the ATM.
Anyways, you know what I love though now? Like it used to, yes, we will watch the rest of Bricks and Minifigs. We'll do a Fig Friday. So that's what we're going to do. We're going to do Bricks and Minifigs Fridays. So it's just so funny to me that she is like, I love that her character, there's a character evolution here that we're having that's just like,
What are you, poor? Necessities are at Macy's. What am I, a peasant? Oh, God. Gotta sit around here in these courtrooms with all these. What are you? Middle class? Yuck. Oh, it's dirty in here. It's dirty. Great.
that's how I imagine her now. Like, as we're starting to have more character development, that's how I'm imagining her just around like regular people. She's like, gross. What do you make? $150,000 a year? Okay. No, thanks. Apparently that's a meme. I don't need him to see the one. Wait. Your old started screaming, I need this. My mom's homeless at the party. Oh my God. She's homeless. Hey, TVJ, how are you? I make people smile. I help people.
What do you do? You get out, you go to, what's work? What do you do for work?
You know what really pissed me off? Let me tell you something. That bitch that got bumped from my chat yesterday, you can be a conservative all you want. You can say a bunch of dumb shit. You could be purposefully obtuse. The fact that she misconstrued my words, he or she, whoever it is, and said, oh, you have to have ambition to be a garbage man. Bitch, don't ever slight my fucking husband. Don't. You can have ambition and do anything. Fuck you. Anyways. Bathroom basic tap today. Oh no. Never explain yourself to someone committed to understanding you. Misunderstanding you. Actual justice for Mr. Bearzz. Let me tell you something else about that ambitious garbage man. How many children do you have dressing up like you for Halloween? Probably 0, bitch. 0. You want to know what's awesome? My husband has little boys on his route that dress up like him for Halloween. And they come out and they run after the truck and they scream because they are so excited to see my husband every day. What do you have? Nothing? Justice for Mr. Bearzz today. We're going to have it. Actual justice. Actual justice. So, there's one difference. My husband throws garbage. You are garbage. Okay? Slam poetry. All right, let's go. I'm done with this shit. Ooh, guys, I'm feeling extra spicy today. You guys got the maple pepper bacon. Anyways, highlight of the week. My 3-year-old gets so excited to see the garbage man every day. They seem happy to see him too. Oh, by the way, that's the other thing. My husband has a wonderful salary. My husband has a great salary. Our insurance is really great. And my husband works his dick off every day. Everybody clap for Mr. Bearzz. He works so I could be on the internet doing this wild shit. However, at Christmas time, people are lined up to throw him more money and cookies and candy and all sorts of shit. So, yeah, that's that. Kids love the garbage man. My husband is a hero. But yeah, let me just tell you, don't ever come in here and say some dumbass fucking shit about my husband. I'll kill you. What the fuck? I'm not constantly talking about my son, but my dude was obsessed with Oscar and all the garbage trucks when he was younger and had an amazing one, and let him sit in the truck. Oh, my husband, when the parents are out, he's like, come on, man. He lets them go, like, get in the truck and, like, pull the horn and whatever. Mr. Bearzz deals with the garbage so that Bacon can talk about it. Yes. Anyways, all right. Let's talk about more trash, shall we? In his own, we would buy him gift cards in his own Oscar plushie. Oh my God. Oh my God. And then there's this, I'll have him send me a picture. There's a pit bull on his route, a giant pit bull with a fat ass head like this. And her name is Princess. And Princess loves my husband. So my husband has started going to the store to buy her own treats so that he can see her every Tuesday. You want to know what else? Let me tell you something else about my husband. You know what? Fuck this. Let me tell you something. He's got a little girl. I'm sorry. He's got a little woman. Thank you for the flowers or the jewels, or the flowers, wildflower. So my husband's got this little woman named Dorothy. Who is sitting in her walker. She's got one of those walkers you could sit in the middle of the snow. Okay. He comes up and he always takes their garbage cans back to their garage. He doesn't have to do that, but he does it. So anyways, he walks up behind Dorothy. You know what she's doing? In the middle of a fucking blizzard, she's shoveling while she's sitting in her little handicap chair. And he goes, Dorothy. And she's like, ah! And she turns around. He goes, what are you doing? And she goes, I'm shoveling. He goes, Dorothy, get your ass inside. So she picks up her walker and she goes inside. You know what my husband did? Shoveled the rest of her fucking sidewalk. What are you doing besides spewing bullshit in my chat. Nothing. Suck my dick. Anyways, okay, here we go. I'm going to tell my husband, I'm going to be like, just watch the first 10 minutes today. So I always try to get my husband on the stream. He's like, I won't do it. He's like, we got to keep the allure that I'm cooler than I am. He's like, never meet your idols. He's like, what if I get on there and people hate me? Oh, God. All right, let's go. So in, isn't just a garbage man. He is a pillar of your community. Yeah, he is. He's wonderful. I am hot and spicy today. Don't play with me. I'm that black pepper maple bacon today. Okay. Also, this is the ex parte application for continuance of hearing. Mallory, thank you. I will speak for all of us. So she wants a continuance. This is from Laura Owens, petitioner in proper. All right. You know what? Because I don't want to get through this today, we are going to have fun with this today. Oh yeah, ghost pepper bacon. Hey, not all Karens. Extra salty bacon is why I am extra salty all the fucking time. All the time. Let's see, what kind of music can we have today? What do we want? We need something that gives Laura I need like ironic I'll just type in ironic and see what it comes up with. Like ironic sad. Game show silly. The dance flow silly. Let's go sad. Because I know she's gonna complain. Salt packets on me so I can throw them at people so they don't have to. All right. Ironic sad is a good one for her. All right. So this is Laura Owens discussing why she needs a continuance.
Laura Owens respectfully requests that the court continue the long cause hearing currently scheduled for October of 2025 and adjust all related deadlines. Good cause exists under California rules of court because of petitioner's medical condition. Her father's recent hospitalization and her ongoing yet diligent efforts to secure counsel through approved legal referral programs. This matter has been designated a long cause evidentiary hearing, not a short or summary proceeding. Given its complexity, the overlapping emotions, and the public nature of the record, petitioner cannot adequately represent herself.
Narrator, petitioner can never adequately represent herself.
A short continuance will allow her to secure counsel and participate fully and fairly. Factual background 1. Family medical emergency. Petitioner's father was hospitalized last week and continues to require 24/7 care. Petitioner has been assisting daily with his medical management. Petitioner's medical condition. Petitioner has been advised to receive urgent evaluation and treatment for gastrointestinal bleeding. Efforts to retain counsel. Petitioner has been declared indigent by a court in Arizona. Hold on a second.
So hold on. Time out. So you've been declared indigent. When is this? 2025. Okay. And now you're claiming that you're indigent again in 2026. It's July of 2026 and you're like, "Hey, I'm still broke." I thought when your lawyer says that you had a well-paying job or that you worked very hard and now you can't work because of this, when was that? When did you have this good paying job? When did you have this amazing career? This lucrative business? When did you have this? Because there's a lot of times that you claim to be indigent because you're simply not working. So sorry, Karen, I'm sorry. I'm sorry. I need a booster seat. I'm sorry. Okay, we're back.
She has actively sought legal representation in this case through the San Francisco Bar Association's Lawyer Referral and Information Services. And all for the Family Legal Clinic. She contacted both by October 2025 and remains on their waiting lists. Both have said they will be able to assist if she can wait 2 to 4 weeks. These are legitimate, ongoing efforts showing diligence and good faith, like my parents in their bankruptcy case. Diligence and good faith in paying life insurance and Macy's cards instead of their mortgage. This case has been designated a long cause hearing and involves multiple pending motions and evidentiary issues. It has also drawn public attention through a group known as Justice for Clayton, which reposts and comments on case filings, even though it's their right to do because, case filings are public. So, whatever. The harassment and publicity surrounding this matter are described in prior filings by attorney David Gingras, my attorney David Gingras, the attorney David Gingras. Petitioner requires counsel to ensure filings are accurate, complete, and not misused publicly. Like I misuse the legal system. Petitioner contacted opposing counsel Omar Serrato to request a short continuance while she secures counsel and addresses these medical issues. Counsel has not stipulated to a continuance as of this filing. Then she goes on to give some examples. Her temporary medical unavailability, her father's hospitalization, and her documented, diligent attempts to secure representation and constitute excusable circumstances under the rule.
I love that she tells you that she has temporary medical unavailability and doesn't give details, and then also her father's hospitalization and also doesn't give details about like what's happening. Okay, great.
Further, this rule directs the court to consider all the facts and circumstances that are relevant, including the proximity of the hearing date, whether there have been previous continuances, the length of the continuance requested, and whether the interests of the justice are best served by a continuance. The hearing is less than 2 weeks away. No recent continuances have been requested. Petitioner seeks a modest 45-day continuance. Hi, Lana. Respondent will suffer no prejudice while petitioner will face extreme prejudice if forced to proceed unrepresented in a multi-day evidentiary hearing. Prayer for relief. Petitioner requests that the court continue the long cause hearing for approximately 45 days, or such further time as the court deems appropriate. Maybe forever, so I don't actually have to go through with this. Adjust all associated deadlines and grant such other relief as the court deems just and proper. Respectfully submitted, Laura Owens.
Anyways, so with that, Owens requests a continuance and supporting declaration citing her medical condition, her father's recent hospitalization, and her ongoing yet diligent efforts to secure counsel through approved legal referral programs. And the request is denied. What does the declaration say? I'm sure it's forever. Good morning, Charlie. How are you? Okay, so we just saw this in there. Great. Love to see it. All right, so 10/7/2025, unable to stay away, David Gingras files a non-party intervener reply in support of his motion to leave for sanctions, opposition to respondent's motion to disqualify. We had that, I believe. Let's see, who is this from? David Gingras. Great. Oh, good. It's going to be long and take forever. I love that for us. All right, now we need some silly music. Because perfect. Non-party intervener and former counsel to petitioner Laura Owens, David S. Gingras respectfully opposes respondent Michael Maricini's motion to disqualify. The motion should be denied and the court should sanction Mr. Maricini's counsel, Omar Serrato, for bringing it. It is unfortunate this court must waste its time considering the issue of disqualification, especially on shortened time. As explained below, the question of disqualification is both moot and objectively frivolous for multiple independent reasons. First, the attorney-client relationship between the undersigned and the former client, Ms. Owens, was voluntarily terminated before Mr. Serrato filed the motion. Okay. Conflicts of interest. Did we read this already? Mr. Maricini had never had an attorney, client, or other confidential relationship with Gingras. For that reason, even if a conflict exists, which none does, Maricini has no standing to raise in this argument. The conflict is the fact that Michael Maricini has a bar complaint against you. So, yeah, that's true. Lowe conveniently ignores that respondent Mike will be harmed by the continuing of DVRO. Great point, Tea Time. How are you? Oh, God. All right. So, and he's a witness. Motion raises two main bases for disqualification. Okay. This is moot. Okay. Basically, he doesn't. We've already read this. So basically what he says is there's no conflict of interest and he should be able to represent Laura. But then he said he wasn't going to represent Laura. But he did not send me his Gingras emails. I have to get those from him. And then Omar is like, there is a conflict of interest. And Gingras is like, you know what? Punish this man. To the praise of your husband, he is a stand-up guy. He is. Sometimes he's a sit-down guy, but mostly a stand-up guy. Anyways. All right, so 10/10/25, a virtual hearing occurs with Judge Gold, Omar Serrato, and Laura Owens present. Several issues are discussed, including Owens' request for a continuance to appear virtually. Both are denied. Are we going to be able to see this? Ugh. Why can't I see anything? All right. Well, those are denied. So we have those. On 10/13, Michael Maricini files his witness list, and his witness include Clayton Eckerd, Greg Gillespie, Greg Woodnick, John Berryhill, which is the guy who forensically dumped his computer, and an investigator from Arizona. On 10/13 of 2025, Laura Owens files her witness list and exhibit list, includes her in her witness her blah, 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 included in her witness list are David Gingras, Karen Bernadis. That's her name. I thought her last name was something else. Napkin Lady, founder of the Huffington Post, Ariana Huffington. What? And the owner of 2 social media accounts associated with JFC. Who's that? While Laura submitted her exhibit list, she never presented Michael Maricini or his legal counsel with any actual exhibits. Oh, she got married. Okay. Hi, Tiff. Witness list redacted. Okay. So the first one is David Gingras, attorney. Okay. Gingras will testify that on April 19th, Michael Maricini's attorney, Randy Supala, confirmed in writing that my client will not be testifying in the Arizona paternity case. Despite this assurance, Michael traveled from California to Phoenix and appeared in person at the Maricopa County Superior Court, where he sat approximately 20 feet because they got out a measuring tape from petitioner for over 2 hours while she testified. He contacted the police. Following this incident, Michael Maricini publicly admitted in a recorded interview that he would not be attending, or he would not be testifying. Yeah, what? I need to know. You could hear Laura. I thought she was on this. I thought she was on it. Mr. Gingras also possesses the knowledge of Mike's involvement in providing a laptop to a forensic examiner that resulted in a 2,500-page extraction, and they were leaked online to a group called Justice for Clayton, which is dedicated to harassing petitioner. Listen, if petitioner didn't do harassable shit, people wouldn't have a reason to say stuff on the internet. I think we should. You know what I need? I need a Judge Gavel sound. Motion granted, Bruce. Let's all meet Jimmy Fallon. All right. So then we have Michael Maricini, expected to be cross-examined regarding his continuing violations of the San Francisco Protective Order, his repeated public misrepresentations about Laura, and his ongoing use of coercive control and reputational abuse to circumvent court restrictions. What? Respondent has engaged in a sustained campaign of post-separation harassment.
Remember, people, almost everything is life-threatening when you're 89 pounds. Most of you wouldn't know this.
Oh my God, are you now calling us fat and poor? Jesus, Laura. Jesus, calm down. Calm down. Thank you for that super. Everything leaks, including her beehole. In that same interview, respondent admitted that he traveled to Arizona, and that he wasn't going to testify. He also leaked or authorized the publications of private texts to Justice for Clayton. These acts were intended to retaliate, harass, and humiliate petitioner in direct violation of the spirit. Hold on a second, though. Do you guys remember that she also put out stuff that she was like, this is great proof. This is the evidence you need. And it was still embarrassing to her? Still embarrassing? Ugh, burritos and Dominoes. Sharing texts aren't right. But you know what are leaks? Probably when they put up Michael's deposition, right? Let's see. Respondent further alleged that petitioner traveled to New York to confront his employer's HR department and asserted that she has pursued communication, harassed, and publicly confronted him. Claims that are entirely false. So she didn't go there. Petitioner has had no contact of any kind with respondent since 2018 and has never known his employer's name and has not initiated or encouraged any communication or confrontation. Okay. Respondent's conduct, including the willful violation of standing protective order, public exploitation, and the confidential material and decimation of defamatory narratives, demonstrates an unbroken pattern of coercive control and reputational abuse, warranting renewal and extension of the protective order under Family Code 6345. Well, if it's that important to you, Laura, why don't you go to the court and get it? Go to the court. Peggy Maricini and Stephanie Maricini. You're calling his mom and sister to testify? Oh, this music is perfect. Expected to testify regarding their close and frequent relationship with Laura during her relationship with Michael, including multiple family gatherings, dinners, and shared events between Maricini and the Owens family. Both women personally witnessed petitioner experience a grand mal seizure in Petaluma, California, shortly after an incident of physical abuse by a respondent. Are they going to testify to that? Peggy sent her son a text message the following day stating, "I don't want you to be my son because of how you treated her." Which even respondents' own witness John Berryhill acknowledged as authentic. You know, I always am astonished at how low you can go. I really am. Like, there's every time I see something new, every time I take in new information, it's crazy to me how low you can get. And you put in, quote, "I don't want you to be my son because of how you treated her," from his mother. Wildly out of context. With the fact that you faked medical conditions, with the fact that you faked pregnancies, with the fact that you faked abortions. Did you ever tell Peggy this? Did you ever tell her that you ran her son through the ringer? When did they see you have a grand mal seizure? When you fell off that horse because you can't ride for shit and you have to compete in a ring with third graders? Ma'am. Oh my God. Her contemporaneous messages to petitioner described her. And you know what? Let me get back to another point. You fucking slut. Let me get back to another point. Okay? I'm a mother of a son. Okay? I love my son to the ends of the earth. But aside from that, I am a woman. And I am a woman who has experienced assault in my life, which puts me in quite the predicament if I were to be in Peggy Maricini's shoes. And that's the thing. This sentence here tells me that Peggy is such a kind lady that she couldn't possibly fathom that someone could lie about something so grotesque. But you can, can't you? With ease. You can lie about something like that. Because you're scum. And it seems like Michael, and that's the one thing that we have talked about with Greg and we've talked about with Clayton. All these people have come from what we would assume are good, normal families. Michael had no idea about the caliber of person that he was dealing with when he met you, because he had a relatively normal life. Someone like me, I could smell your bullshit from a mile away. But someone like Michael and someone like Peggy, who did her job as a mother, unlike Jan Black, raised her son to be a good man, to be a good, honest person, to be the kind of person that through all of your patience or through all of your bullshit showed you patience, showed you kindness, and showed you honesty. And she said this to her son because in my brain, she probably could not fathom that somebody would lie about something so egregious. You know, there are times I didn't feel bad. I didn't feel bad yesterday. There were times where things have gone with this case and I'm like, oh, I feel bad. I don't feel bad for you anymore. Calling CPS on this family, manipulating his mother, manipulating his sister, isolating him from everybody that loves him so that all you can do is drown him because you are a toxic swamp thing. And you are so alone at the bottom of your fucking swamp that you are so desperate to just drag another human being to the depths with you. It's crazy. It's crazy. And I don't feel bad anymore. I don't feel bad. You staring down the barrel of 14 felony counts, coming up to trial. And either way, you go to trial or you take the plea deal. Those two things for me, knowing that they will publicly be the most humiliating thing that happens to you, brings me so much fucking joy. The ripples that you cause are disgusting. You're disgusting. Hi, Kelly. Good morning. Oh, God. Anyways, her contemporaneous message to petitioner described her as so loving and caring and so blessed you are home with your sister and daddy, confirming the seriousness of the relationship and undermining respondents' current claim that it was casual or delusional. So loving and caring. You know what's so interesting about this quote? So loving and caring is what you can show people. But I find satisfaction in the fact that you'll never feel it. You are so empty inside. You know what loving and caring looks like, which is why you're able to manipulate people. But you have no idea what that feels like. And that's a sad life to live. Petitioner also retains multiple voicemails from Miss Maricini that you used against her and leaked on the internet. You fucking tea towel. Many recorded after she had distanced herself from Michael, in which Miss Maricini pleaded for renewed contact, reflecting both emotional distress and implicit recognition of her son's culpability. My life skills class after this. Let's go. Let's take them all to church. Here's the thing. As a mother, if my son was ever blamed of abuse, he's my son. I don't want to believe that a victim can lie. I am also not a person who takes things at face value, mostly because I've been fucked over for a good portion of my life. So now I'm very guarded, even when I shouldn't be. Which is something that I'm trying to work through. It's something that I try to get through. It seems like Peggy Maricini is a very open, very loving, very trusting human being. And like a predator on prey, you can smell it. And you did everything that you could to get her to trust in you and to believe you. I mean, I have higher aspirations than that, but, you and I are different. If this were my son, you'd have to prove it.
Miserable people like Lo want company, and she's willing to use anything to get it, and if that company rejects to her, she'll punish them forever.
Anything. Anything. And there's no standard. Thank you for that super varsity. There's no, the limit does not exist at all. Let me tell you though, if I found out that a girl was doing this to my son, and I found out that I was wrong, and I trusted you, and you were lying the whole time, I have no chill. I would drag you to the depths of hell. The depths of hell if this was happening to my son. And it seems like Peggy Maricini is a wonderful, loving, compassionate, empathetic, trusting mother. And it doesn't seem like she's going to do it because that's just not her type. But it's my type. So, Peggy, today's stream is dedicated to you. I came in hot today. So let's get to Stephanie, who is his sister, also socialized frequently with petitioner, borrowing her car, dining together, and exchanging messages acknowledging respondents' volatility. So you became friends with her to try to get in with her, to try to get that trust. Hi, Addie. Yep, it would be my life's mission. I know that's right. Since 2023, his sister has aligned herself with online harassment networks defending respondent and targeting petitioner, including Justice for Clayton. If that was my brother, the way I would wrap my car in a Justice for Clayton sign with a fucking auga on the top of the fucking roof and drive it around your neighborhood, bitch, I fucking swear to God. I swear to God. Posting under the handle Justice for MM. She has publicly identified herself as Michael's sister and leaked previously unseen photographs she personally took of the petitioner to the Justice for Clayton official Instagram. These included images from May 2017 horse show and a private birthday dinner, confirming her as the original source of private material later used to harass petitioner. Good Lord. It's hard for people that haven't experienced the darkness of these personalities to fathom they exist. Nothing wrong with it. I love that some never see it. Yeah, and that's the thing. Oh my fucking God. Miss me, this is so funny. Laura is nuttier than a porta potty at a squirrel convention. Either you did this or you didn't. If you did, she should want to run from you, but not try to make me hold you together. If you didn't, are you okay with her saying this about you? Yeah. Yeah. I mean, right. You were in public. And the occasional great cigar. Ugh. Taken together, Peggy and Stephanie's prior statements, actions, and communications provide direct, independent corroboration of respondent's abusive behavior and evidence of coordinated ongoing efforts by his family to intimidate petitioner and undermine the protective intent of prior court orders. What? Spoiler alert, my son did not do this. Hell yeah. Yeah. Actually, she wrote this. Linza. She wrote this. All right. So then we have Michael Maricini's ex-girlfriend, former intimate partner of Michael, who independently contacted petitioner to confirm that petitioner's prior warnings about respondent's behavior were accurate. What? In her messages, she stated, "Some things happened and I would prefer to stay far removed from him. And I just wanted to say thank you for giving me the heads up on Mike, and I apologize for not believing you at the time. Woman to woman, I just want you to know that I appreciate what you did." She also wrote that she blocked him on every platform to avoid further contact. Although the communication occurred in 2018, her account remains highly relevant under family code because it independently corroborates a long-term pattern of coercive control, emotional volatility, and retaliatory behavior that continues to drive petitioners' ongoing reasonable fear. Her testimony provides objective validation from a separate partner who, after direct experience...
Behind on stream, growing up my parents had coffee ready for the garbage men every week. I remember them pouring something into their cups.
Was it liquor? Was it liquor? Thank you for that, Maria. That's so sweet. You just made my huh face. For real. What? For what? Ugh. Hi, Hound Servant. McLean's account remains high. Okay. Her testimony provides objective validation from a separate partner who, after direct experience, chose to sever all contact from her for her own protection, underscoring that respondent's behavior presents an enduring threat, not an isolated past event. Do we know this to be true? Yeah, I'm going to need the metadata for this. And you know what's very interesting? TVJ, look at this. So she has these text messages, which even respondent's own witness, John Berryhill, acknowledged as authentic. Okay. What do you have in here that proves to me that this is authentic? What is the date of this filing? 10/3/2025. Then we have Julia, competition safety coordinator of the United States Equestrian Federation. Great. Great. Yep, give me the metadata. John Berryhill is the forensic agent that dumped Michael Maricini's laptop and authenticated all of the text messages and all of like the emails. He used to hang off the side of a shopping cart and pretend he recently said he would love to have that job. He used to run and wave to the garbage men. It's so funny. It's like everybody wants to be a garbage man. It's hard work, though. You better be able to work. Expected to testify as neutral records custodian and expert witness regarding petitioner's official USEF competition history, safety logs, and incident reports. In Mike's motion to dismiss DVRO pursuant to CCP, his counsel alleged that petitioner rebranded horse fall injuries as domestic violence bruises, citing competitions in February of 2017. Ms. Brozek will testify that the official safety records reflect no reported falls, injuries, or on-site medical incidents involving petitioner at any USEF sanctioned competition by 2016 or early 17, including those cited by respondent. Okay, but you also can't prove, right? And this becomes a sticky situation. I talked about this with Schnitzel. God damn it. Schnitzel Ninja. Schnitzel Ninja. You don't ever want to ask a victim for more proof. You don't want to do that because a lot of times you don't have the proof of where it came from. But in this situation, when your lies are 10 out of 10, where is the proof? Where is the proof that you had it from Mike? You don't. You don't. Unless I see, what was his name? And it wasn't Jerry Rice. Fuck. Who was it? It was that football player. Was it Jerry Rice? The football player who, like, beat the shit out of his girlfriend and then dragged her out of an elevator? Unless I see some shit like that on a video of Michael Maricini doing this to you, I don't believe a goddamn thing. I don't believe a goddamn thing. Diddy? Sounds like Diddy. Could be Diddy. But no, I'm thinking of somebody else. Not Jerry Rice. Ray Rice. Thank you. Yes. Isn't there video of Lowe falling off a horse? There is, and they were there. Yes. Yes. That man beat the living shit out of his girlfriend, pregnant at the time, and dragged her out of an elevator. Instant, right? Unless I see something like that from Michael Maricini, I don't believe shit that you say. I don't believe shit that you say. None. The only recorded equestrian-related event occurred in May 2017 when petitioner experienced a grand mal seizure while mounted at the walk on a horse at a USEF sanctioned competition in Petaluma, California. She fell as a result of the seizure, not a riding error or accident, and was treated and released the same day without overnight hospitalization. You slowly falling off that horse was a grand mal seizure? The incident was witnessed by Peggy Maricini and Stephanie, and independent observers confirm that they were present and followed petitioner by car to the hospital. Okay. Were they in the room with you? USEF's mandatory reporting protocols require documentation of any rider, fall, or medical transport. No such records exist at any other time in her competitive history, confirming that she has never been hospitalized for any fall. This neutral governing body evidence directly disproves respondents' claim that petitioner's injuries were equestrian-related and reinforces eyewitness accounts showing that her May 2017 medical emergency was a result of a seizure, not a riding accident. These eyewitnesses can't say shit. They're not fucking doctors. All I saw was your stupid ass fall off a horse. I don't know why. Wait, read that again. My ears do not comprehend. It's going to be blood. Just blood is going to come from your ears. It's just, all right. Then we have Karen, napkin lady, neutral third-party eyewitness who personally observed Michael verbally and emotionally abused petitioner on an international flight. She wrote contemporaneously that respondent was so menacing that I felt her life was at stake were she to stay with him, and slipped petitioner a note urging her to seek help. In 2023, she publicly recounted the same event in Chicken Soup for the Soul, Get Out of Your Comfort Zone, Simon & Schuster. Writing that situation was so dangerous that I couldn't even risk sharing my phone number. A recent publication provides contemporary corroboration that an uninvolved stranger perceived respondents' conduct as life-threatening, supporting the continuing reasonableness of petitioner's fear and the need for renewal of protection. Let's talk about this. She may have seen that. That may have been the way that she perceived those events. Because I could imagine Mike Maricini screaming at you, which they said he didn't even do, but saying just horrendous shit to you on a plane. And he's 6'4" and you're, I don't know, what are you, 3'7"? I don't fucking know. But anyways, him saying a bunch of shit to you, right? Somebody would perceive it as violent and dangerous. What they don't understand is that for the past year or 2 year, you've been faking pregnancies, radio jobs, abortions, health scares, your father's health scares. He's tired. He's tired. Yeah, she needs new incidents. Records custodians, Child Protective Services and Human Resources Department. Expected to testify or provide certified documentation regarding 2 discrete factual issues raised by a respondent in this proceeding. Child Protective Services records custodian or assigned investigator is expected to confirm that a CPS report concerning respondent was received and investigated in 2024. Petitioner was not the reporting party. Who was? Who was? Anonymous? Because I don't believe that you have... Oh, yeah, fake cancer. I forgot about that, too. Yes, she did sue Uber. She did. And she ripped earbuds. Right. Yeah, right, Jan. Who was it? Sarah? Ron? Blora Blowens? What the fuck? Petitioner nor any of her family members was identified as such. Is it possible you could have given him a false name on the phone? The report's existence became public only after respondent and his online affiliates discussed it on Reddit, falsely accusing petitioner and her family of making the report. In reality, the report originated from an independent third party who found respondent's conduct sufficiently concerning to alert the authorities. Name them. Name them. The fact that a neutral observer viewed respondent's behavior as warranting a CPS report supports the inference that others, not only petitioner, continue to perceive him as threatening. Respondent's subsequent effort to weaponize and publicly mischaracterize the report further demonstrates his ongoing use of intimidation, deflection, and reputational abuse, all consistent with coercive control under Family Code 6320. Second, HR department. Petitioner has never contacted, visited, or communicated with any HR personnel, and no record, visitor log, or correspondent supports respondent's claim that she made an impromptu stop to discuss the existence of the DVRO. This verification will establish that respondent's allegation was entirely fabricated. I'd love to hear it. I'd love to hear it. Joan O'Neill. These are the Cooperative Restraining Order Clinic, recanting witness and rebuttal counsel. Former friend of Laura Owens and the attorney of record who handled petitioner's DVRO filing through the Cooperative Restraining Order Clinic. It's all redacted. Okay. Why is this redacted? Right. Mention it all. Name them. So this is from her friend? Attorney Justin Cook will testify to the preparation and submission process, confirming that Ms. O'Neill's declaration was independently authored and transmitted through CROC, and that petitioner played no role in drafting or editing the statement. Okay. She still could have said it under false pretenses. How the fuck would she know why CPS was called unless she knows who did it? That's a great point. Together, their testimony directly rebuts respondents' allegation of fraud in the 2018 filings, clarifies the provenance of the declaration, and establishes that any later recantation arises from personal motives, not factual error, offered solely to address credibility issues in the present proceeding. Miss Ariana Huffington public figure.
My friend, Miss Ariana Huffington. You guys wouldn't know her because you're fucking poor. Anyways. Too broke to read the Huffington Post, unlike myself. Public figure, known to petitioner's family through her father's professional career. Miss Huffington will confirm that she has never met, spoken with, or interacted with Mike in any capacity, directly rebutting respondents' false public claims of association and thereby impeaching his credibility, because she's my friend, not his. Her testimony will demonstrate respondents' ongoing pattern of fabrication and self-aggrandizement, further undermining the reliability of his reputations to the court and to the public.
Shut the fuck up. Owner and operator of Justice for Clayton Official and victims of Laura Owens. Identity unknown.
I don't know who they are, and I don't know how to get a hold of them, but they're gonna come in and testify. They are. To be identified via subpoena to Meta platforms. Expected to testify regarding the authorship, operation, and content sourcing for the Instagram accounts, which have engaged in coordinated online harassment, defamation, and indirect contact directed at petitioner in violation of the San Francisco DVRO.
How? Petitioner intends to subpoena. Yeah, all right. I can't wait. Dude, I hope they call me and they're like, can you spell your name for the record? It's Bacon Bearzz? Yeah. Bacon like the food, bear like the rar. 2 Z's at the end. Just. All right. God. Let's see. Petitioner intends to subpoena Meta platforms to identify the subscribers, registered email addresses, IP addresses, and device logs associated with both accounts, as well as upload metadata for the posts compiled in the... You want metadata, bitch? You want metadata? Your metadata says... a Facetune. What? The operator's testimony is necessary to authenticate those records, confirm content origination, and establish that respondent and or his counsel provided, approved, or directly coordinated the dissemination of materials used in these posts. How private materials, including photos, videos, and screenshots, known to have been... You know what's so funny? You manifested... being a public figure. I bet this wasn't on your fucking vision board, was it, bitch? You better go to one of those TikToks, like, one of those TikToks that tells you how to manifest and, like, hone in your skills. Because, you're a public figure now. You are a content creator. That's for sure. Oh, I miss Donkey Kong. That was such a good game. Good Lord. All right, so she wants all of these. The testimony will authenticate Exhibits 22 and 23 and establish that respondent maintained ongoing communication with the operators of both accounts, constituting indirect harassment. She gets it subpoenaed, and it's her mom. Thank you, Princess Warrior. Even if respondent denies authorship, the operator's admission combined with the subpoena platform data will demonstrate that he knowingly supplied, approved, or facilitated the release of private and litigation-sensitive materials. Which are what? Ongoing. Ongoing. Oh, God. Who else is in here? Oh, good, we're done. So now we're on October 16th. Laura files a motion in Lemonade asking the court to exclude virtually every witness listed by Michael Maricini. If her motion had been approved, the result would have been an exclusion of many of Laura's own witnesses, a repercussion Laura likely hadn't considered. Yeah. I need a fan. Oh, here's our motion in Lemonade. She's just such a silly, quirky girl, guys. She's not like all other girls. She's not like everybody else. Oi. All right, so here we go. We got this. Laura Owens, pro per. Mr. Woodnick is thus offered not as a percipient witness, but as an expert to give personal opinions about petitioner's credibility and mental state topics that are inadmissible under California evidence law. What is this? Oh, this is... All right, Section 1, to exclude witness Greg Woodnick. Mr. Woodnick has no personal knowledge of petitioner's relationship with respondent Maricini. His only involvement with petitioner arose while he represented other clients in Arizona. Those unrelated proceedings have no bearing on whether petitioner continues to harbor a reasonable apprehension of future abuse from respondent as required by family code. Testimony lacking firsthand knowledge is inadmissible. That's right. Greg Woodnick knows nothing about you. We believe you. The record establishes an extraordinary conflict of interest. According to the court-generated email chain, petitioner reported to the Maricopa County Superior Court that she had been assaulted and had strong reasons to believe that both the defendant and his counsel were involved, and that there was a pending FBI investigation. The court's judicial assistant forwarded that message to Mr. Woodnick and reminded petitioner that ex parte communication was not permitted. How dare they? How dare? How dare they follow the rules? From that moment, Mr. Woodnick became aware that petitioner had personally accused him of serious misconduct. Oh, no. Oh, no. It's almost like your actions have consequences, you dumb fuck. Since that disclosure, his actions toward petitioner have reflected sustained hostility. Yeah. What? You accused this man of orchestrating your rape and putting it on the dark web with no proof. He has described... Fucking idiot.
He has described petitioner publicly as someone who, can you believe it, fabricates abuse allegations. Who would do that? And suffers from unreasonable fear? In March, while representing a different adverse party, because I have so many. Hi, Jen. How are you? He issued a Woodnick Law press release repeating those phrases and asserting that petitioner had falsified evidence. Statements made months before any evidentiary hearing or ruling in the Arizona matter. Petitioner later filed a State Bar of Arizona complaint documenting that press activity as other unprofessional conduct. That'll show you, Greg Woodnick. Although the bar had closed the file without formal discipline, the existence of that complaint demonstrates that Mr. Woodnick's professional conduct was formally challenged by this petitioner, even though they closed it because the complaint held no merit. Having been personally accused of abuse and professionally reported for misconduct, Mr. Woodnick now seeks to testify as an expert. That petitioner fabricates abuse allegations. That sequence creates a textbook retaliatory motive under Evidence Code 780, a desire to vindicate himself by discrediting the complainant. Bias and hostility go directly to credibility. Such bias renders him incapable of neutrality. Under Family Code 217, the court may exclude testimony that would cause harassment, intimidation of a protected party. And under evidence, it may exclude evidence whose probative value is outweighed by the danger of undue prejudice. Mr. Woodnick's participation meets both standards.
It is true to the best of her ability. Hi, Brad. Improper expert and character testimony. God, we're still talking about Woodnick. Woodnick proposed opinions that petitioner fabricates abuse allegation or acts from unreasonable fear, concern, credibility, and emotional state, or not any field of technical expertise. Admitting those opinions would usurp the court's role as fact finder. Can't believe vibes aren't proof. Just go with me. Just go with me, okay? Just meet me where I'm at. Respondent's disclosure asserts that Mr. Woodnick will corroborate findings in Arizona paternity litigation. The representation is incorrect. The Arizona cases contain no judicial findings that petitioner fabricated abuse allegations or lacked reasonable fear. Any claim to the contrary is a misstatement of the record and should be barred as misleading under Evidence Code 350 and 352. A renewal hearing is not a retrial of the original abuse allegations. You're right. It's a renewal hearing. We need new allegations. Where are those? Unfair prejudice and confusion. Permitting Mr. Woodnick to testify would transform this renewal hearing into a collateral trial on Arizona disputes, disciplinary filings, and press publications. The minimal probative value of such testimony is far outweighed by the danger of unfair prejudice, confusion of issues, and harassment of the protected party. On October 3rd, Respondent's Counsel, Omar Serrato, issued a purported trial subpoena to Woodnick, commanding his appearance at San Francisco court hearing on October 21st. The subpoena is procedurally defective and unenforceable for multiple reasons. So is this why you didn't show up? First, the subpoena seeks to compel the attendance of an out-of-state witness residing in Phoenix, Arizona. California has no extraterritorial effect and cannot compel the attendance of a non-resident without compliance with the Uniform Interstate Depositions and Discovery Act. No such domestication proceedings have been initiated in Arizona, and therefore this subpoena has no legal force outside California. The form shows no clerk's issuance or court seal, only the handwritten signature of Mr. Serrato. A subpoena for trial testimony must either be issued, leave me alone, by either the court clerk or an attorney as officer of the court, only for the witness in California's jury, blah, blah, blah. Okay, great. All right. These are the reasons she doesn't think he should be able to come. Who else? John Berryhill. I don't want John Berryhill to come. Respondent seeks to call privately retained digital forensics witness Mr. Berryhill to introduce a 2024 report and text messages from 2016 to 2017. Materials never filed in this case and unrelated to the record supporting either the 2018 restraining order or its 2020 renewal. No forensic examination of petitioner's filings have ever been ordered by this court. The proposed testimony is unfounded, irrelevant, and inadmissible. I find it to be highly relevant, actually. Highly relevant. Respondent's 2025 executed exhibit list identifies new exhibits, digital forensics, and items 114 through 118, text messages from 2016 to 2017. These materials were never part of the 2018 evidentiary hearing record that established the restraining order, nor of the 2020 renewal record. Introducing them now attempts to reopen and retry matters conclusively determined years ago. The court files supporting the 2018 order and 2020 renewal in Owens versus Maricini contains no medical letters, no ultrasound records, and no comparable exhibits, let alone anything falsified or misleading. That's because you stopped talking to him in 2018. That's why there's nothing falsified or misleading, because you couldn't talk to him. Neither party nor the court ever referenced or relied upon such materials. Mr. Berryhill's testimony that petitioner filed falsified medical letters and ultrasound images is therefore baseless. So you're not denying it. You're just saying that it doesn't count. Idiot. Testimony predicated on documents that never existed in this record is speculative and irrelevant under Evidence Code 350 and 702, and its only effect would be to mislead and prejudice the trier of fact. No court authorized or neutral forensic review. The court has never ordered any forensic examination of petitioner's filings or devices and has not appointed any neutral expert under Evidence Code 730. Mr. Berryhill's work was privately commissioned by Respondent's Counsel, conducted without notice to petitioner, and performed outside any judicial supervision. A privately retained analyst cannot be presented as a neutral forensic review, and admitting his report could mislead the court into believing that official determination of fabrication exists when it does not. Testimony lacking neutrality or court authorization fails to satisfy the reliability and fairness standards. So get your own. Expert. Absence of methodology or validation. The digital forensics report identifies no software extraction method, imaging log, hash value, or validation procedure. Didn't he give like a whole report about it? It provides no chain of custody, documentation, device identifiers, or metadata establishing authenticity. It merely reproduces fragments of text messages without explaining how or from where they were obtained. Expert testimony based on undisclosed or unverified methods fail the reliability requirement of Sargon Enterprises versus USC. Okay? All data Mr. Berryhill reviewed originated from Respondent Maricini's device and dates from 2016 through 2018, 7 to 9 years before this hearing. Those communications predate the incidents that led to issuance of the restraining order and have no bearing on petitioner's present apprehension of future abuse. And that's my thing. I know all about that. Improper credibility and character testimony. Mr. Berryhill's stated purpose, confirming that multiple documents were fabricated or altered, is a direct attack on petitioner's credibility. Yeah, that's like the whole point, you know. But whatever. California law forbids expert or lay witnesses from testifying that another witness is dishonest. Yeah, we know. Allowing testimony about an unsupervised partisan forensic report and decade-old text messages would convert a limited renewal hearing into a collateral trial on unrelated issues. The probative value of this evidence is non-existent. The danger of unfair prejudice and confusion is extreme. Section 3, to exclude witness Gregory Gillespie. That's the point. Gregory Archibald Gillespie. Respondent proposes to call Mr. Gillespie to repeat discredited allegations from Arizona litigation that were resolved entirely on procedural grounds and never adjudicated as true. No court has ever found that petitioner falsified a pregnancy, submitted a forged ultrasound, or misused protection orders. Such testimony would be irrelevant, misleading, and unduly prejudicial. I mean, she's not wrong. They just haven't caught you yet. But they're gonna. A hearing on renewal is not a retrial of the original abuse allegations. The inquiry is limited to whether the protected party entertains a reasonable apprehension of future abuse. I don't know, Jack. I don't know how they could. I don't know. She just says shit and I just believe it with my whole heart. Ugh. No witnesses can ever disprove any evidence ever. Right. Allegations concerning a separate Arizona civil case have no bearing on whether petitioner continues to fear respondent Michael Mayorchini. I fear him, even though he's 500 miles away from me. And he doesn't want anything to do with me, and he doesn't ever want to see me again. I'm in such fear. I'm so afraid. I'm so afraid. The Arizona record affirmatively shows the absence of any finding that petitioner falsified pregnancy, forged documents, or abused the protective order process. Okay, great. The defendant's own second supplemental rule, disclosure statement filed by, okay, what is this? Reportedly fabricated a pregnancy and subsequent abortion. Petitioner's motion for partial summary judgment established that Gillespie did not suffer a consequent proximate injury and did not incur damages and did not suffer severe emotional distress.
Emotional damage.
I think we would all disagree with that. But, you know. Notice she's no longer saying that the messages on Mike's computer. Right. She's even tired of her own. She's like, I'm tired of this. I'm tired of explaining myself. Ugh. Michael D. Gordon granted both parties cross motions for summary judgment, expressly finding that the damage disclosure made by defendant counterclaimant with the respect to the fraud are insufficient for both claims. For you too. Yeah, somebody go grab Ariana Huffington. Those rulings, she's like, poor Ariana. She's at her house. She's like, don't say my name. Don't say my name, please. Leave me out of this. Those rulings disposed of Gillespie's fraud and emotional distress counterclaim solely for lack of proof, not because petitioner fabricated evidence. No Arizona court has ever entered a finding of perjury, forgery, or false pregnancy. I mean, not yet. Don't worry, we'll get there. Petitioner currently holds an active protected order against Mr. Gillespie and previously obtained uncontested orders. None have been vacated or denied. His testimony that petitioner misused protection orders is contradicted by those undisputed judicial records and should be excluded as false and prejudicial. Foreshadowing, right. Right. What did I do? What did Ariana do? Frosted Flakes is the only one of them with a job. Permitting testimony that petitioner faked a pregnancy, forged an ultrasound, or misused protection orders would misrepresent the Arizona proceeding and mislead this court into believing such findings exist. Oh my God, it's almost like they need to have evidence which you could supply. They could go in there and say that, and you could be like, I've never been found of these things. It's almost like you would have a chance to rebut their argument in these adversarial proceedings. It's almost like you get to talk, and then they get to talk, and then you get to talk again. And if you prove your point, you win. It's almost like this is a ping pong game, but everybody came with paddles except for you. Mr. Gillespie lacks personal knowledge of any facts relevant to petitioner's present relationship with respondent Maricini or to her reasonable apprehension of future abuse. Testimony must be based on personal knowledge. His proposed testimony concerns unrelated closed Arizona matters and therefore is admissible. I mean, she's not wrong, right? Like, he does lack personal knowledge. His knowledge comes from Michael Maricini. But we all get it. Mr. Gillespie remains the opposing party in multiple Arizona protective order proceedings that petitioner lawfully obtained. Lawfully is doing a lot of heavy lifting here. Having been the subject of those orders, he possesses an obvious motive to discredit petitioner. This retaliatory interest falls squarely within Evidence Code of 780. Unfair prejudice and confusion. I am confusion here. Introducing Arizona allegations of false pregnancy and forged ultrasound would confuse and prejudice these proceedings by suggesting petitioner engaged in conduct never proven or adjudicated. Any minimal probative value is vastly outweighed by the danger of undue prejudice and confusion. Oh, that's a good point. Yeah, wait. Closed Arizona matters. And then you're right after that, he remains the because he remains the opposing party in the protective orders. So she's talking about the abortion coercion that she brought. But yeah. Introducing Arizona allegations of false pregnancy or forged ultrasound. Oh, I already read this. Brad, you always got to bring it. Got to keep it in the bag. We have to exclude Terry Bowe, Ty Bowe's lesser-known cousin, Maricopa County investigator. They're getting destroyed in their bankruptcy cases because they can't sell their victimhood. The numbers aren't objective. No. Screenshot this. You just have to translate the numbers. You just translate them. That's what Jan said. You just have to translate them. And then you'll get it. Detective Terry Bowe is a law enforcement investigator from Arizona who seeks to testify about an ongoing criminal case in which petitioner has been indicted, but not convicted. So.
They said that I did these things, but I haven't been convicted yet. And according to the podcast and the judge and the prosecutor, I'd have taken the plea deal a long time ago to admit guilt, but, without jail time. So there's that.
Idiot. But how can Mike's IT expert authenticate? I wonder if Mike's mom gave up her phone, maybe? Right, just put the numbers in context. You need to know about the context. The subpoena served on Mr. Bowe is procedurally void, like your heart. And the subject matter of his proposed testimony is inadmissible under the California Evidence Code. Hey, Lales, how are you? Unsigned invalid subpoena. The subpoena from this judge attached to respondent's notice of subpoena contains no signature or date of issuance on the attorney's signature line. A subpoena must be signed by the clerk of court or by an attorney as an officer of the court. An unsigned subpoena is a nullity that creates no duty to appear or produce documents. Because the subpoena was never validly issued, it cannot support any testimony appearance by Mr. Beau. Mr. Beau is Mr. Beau is unemployed. God, there's so many unemployed people in this case. Mr. Beau is employed by the Maricopa County Attorney's Office in Arizona and resides outside California. California subpoenas have no extraterritorial effect, absent domestication under the Okay, so he can't go there because he doesn't live there, is what you're saying. Great. Defective notice in service. The notice of subpoena issuance merely announces an intent to issue subpoenas and provides no proof of service. Okay, great. At what point when you're filing a legal motion and you mention multiple other court proceedings you've been a part of, do you think this is not normal? How many? What's the number? What's the number? Right? Oh, spoiler alert, he didn't? He didn't authenticate those? Well, I'll be damned. Forensic expert can only claim the integrity of the message database is not obviously tampered with and that the numbers are valid. Oh, hi, chickens. Chickens was the one that sent me on Instagram all those pictures of myself from stream yesterday, and I was dying. So funny. Indictment and ongoing criminal investigation are not admissible evidence. Mr. Beau's proposed testimony concerns an ongoing Arizona criminal case that remains at the indictment stage. An indictment is not an evidence of guilt. It is merely an accusation.
And I have 14 charges.
Hi, Lushburn. From Wisconsin. Would be laid on knowledge personally of the phone number. Mike's, oh yeah. Allowing an investigator to describe findings from a pending case would violate the presumption of innocence and invite prejudice. Hi, Sheebs. California courts bar testimony or exhibits referencing unadjudicated criminal charges because they risk confusing issues and undermining fairness. Mr. Beau's stated purpose to explain the investigative findings showing a deliberate pattern of deception relevant to credibility constitutes an impermissible expert or lay opinion from parties' veracity. I agree with this one. I agree with this one. Like, I wouldn't want to be charged with crimes and then I'm not guilty and then they come into court and they're like, but yeah, find me guilty first. This is A, not criminal court, B, not that case, and C, not that state. She could be Mike's next door neighbor and she would be safe from him. That's how much he doesn't want to see her. Generally allow detectives to be considered knowledgeable on deceit or practices of criminals generally. Right. But the only thing is she hasn't been charged with it yet. All right. She hasn't been convicted of it yet. She's been charged. The limited inquiry on her family code is whether petitioner entertains a reasonable apprehension of future abuse. Criminal allegations from another jurisdiction have no bearing on that question. Introducing testimony about a pending Arizona indictment would mislead and prejudice this court, transforming a protective order renewal into a collateral trial on unproven criminal charges. Section V, to exclude witness number 6, Mr. Clayton Eckerd. We haven't seen you in a while. Mike wants to call Mr. Eckerd to impeach petitioner's credibility based on a prior Arizona paternity and protective order matter. That case involved different facts, parties, and legal issues. It contains no findings of false abuse allegations, and it bears no relation to whether petitioner continues to fear respondent Maricini. He was the Bachelor? No way. Shut up. Nuh-uh. I don't believe you. So wouldn't the same logic apply to Lowe? That's what they say in here at the end of this one is the result would have been an exclusion of many of her own witnesses, a repercussion Laura likely hadn't considered. So yes, he was. I'm gonna have to Google that. I don't know if I believe you. On October 6th. I want to talk about this. I love this. I love it. No shit. Okay. So, paternity and protective order matter. That case involved different facts. Like, what? Because to me, they're pretty identical. Parties and legal issues. It contains no finding of false abuse allegations. Actually, it does. And it bears no relation to whether the petitioner continues to fear respondent Maricini. After the judge literally said in her ruling that Owens' essay claim wasn't reasonable, right? No, he's the fucking bachelor. Got it. There was no TR&B hole. TR&B hole mention. On October 6th, petitioner filed Owens versus Eckerd seeking paternity determination on an order of protection. The protective order was issued that same day after evidentiary hearing on October 25th of 2023 was affirmed. Are we going to put in here that he also has an IAH against you and that you owe him just a cup of what? Right. Over $200,000? Pay up. Mr. Eckerd moved to dismiss and quash the order again, and Arizona Superior Court denied his motion on June 18th. The order remains in effect and has never been vacated or reversed. So.
Just so this court knows, I have 3 successful DVROs.
300K? Is it 300K? I know it's over 200. No ruling has ever found that petitioner fabricated or falsified abuse allegations. And no court has deemed her fear unreasonable. That continuing validity of the order directly contradicts the witness claims that she made false abuse claims. No identical patterns. Girl, these patterns are more identical than your twins, and no relevance to this proceeding. Mike's assertion that Mr. Eckerd's case shows identical behavioral pattern is factually and legally baseless. Petitioner has filed no paternity or protective order case against respondent Maricini. Is this not a protective order case? Is this the fuck? Is this not for a protective order? You guys, she's gaslighting me through this? The Arizona case concerned a separate relationship, unrelated to this one.
So what I'm saying is, I did this with another guy, but it doesn't matter because it was someone else.
Petitioner never alleged that Mr. Eckerd engaged in physical violence. You didn't? You didn't accuse him of rape on the stand? Physical violence isn't just someone like beating the shit out of you. You saying no and them assaulting you anyways could be considered physical violence. And now you're saying in 2025, petitioner never alleged that Mr. Eckerd engaged in physical violence. What would you constitute rape as? Whereas her allegations against Mr. Maricini do. Okay. Okay. These facts make clear that these cases are not identical and that Mr. Eckert's testimony would mislead the court. Irrelevance to renewal under Family Code. Okay, renewal is not a retrial. Because Eckert's testimony concerns unrelated Arizona litigation and even events that predate Respondent Maricini's relationship with petitioner, it cannot assist the court in determining current fear. Lack of personal knowledge. Okay. Livestream meetup. I like it. I want to be there. Relationship be doing some heavy lifting. It's true. Oh, God. Mr. Eckert has no firsthand knowledge of petitioner's relationship with Michael Maricini and did not meet him until 2024. His proposed statements therefore fail the personal knowledge requirement. Mr. Eckert remains the respondent in an active Arizona protective order and has twice sought unsuccessfully to have it dissolved.
Haha, I win, you lose, na 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 boo boo.
Ugh. One night relationship. Clayton was testifying on stuff that predates Mike. Is that what that said? Where did that? No, I think predates Clayton is what she was saying. Which it does. Assertions that petitioner exhibits identical behavior patterns, false claims, or lack of genuine fear are inadmissible character evidence. Okay. The subpoena purporting to compel Mr. Eckert appearance is jurisdictionally void because he doesn't live in California. California. No doubt about it. Yeah, let's ignore that he's listed as an actual victim in a criminal case. That's right. Okay, so this says that. All right. Gregory Gillespie. Again? Are you... Wait. Why is he in here twice? What the fuck? Master Hacker. Okay, Clayton. Terry. Greg. Oh my God. Greg is witness 5 and 7. Holy shit. It's fucking Jason Bourne. Nobody excludes the GG. The Arizona court never made any finding that petitioner fabricated pregnancy or abuse allegations in 2021. Those claims were raised only in Mr. Gillespie's pleadings and were disposed on procedural grounds. He's a dual threat. Oh my God. Petitioner's 3 uncontested protective orders, each entered on filings. Yeah, I love that they're uncontested because he's like, if I have it, you also can't talk to me. Oh, yeah. Dude, if Laura got a fucking IAH against me, I'd be like, hell yeah. Stay as far away from me as you can. Oh my God. Each entered on filings of reasonable cause to believe Mr. Gillespie may commit domestic violence, directly contradict the assertion of false abuse allegations. Okay. A renewal hearing is not a retrial. Allegations concerning a separate Arizona dispute have no bearing on whether I'm petitioner. I'm scared of Respondent Michael Maricini.
Because all the court should know is that I'm scared of everyone.
Idiot. In Owens versus Gillespie, both parties moved for summary judgment. The damage disclosure, all right, was insufficient for both claims. In short, the Arizona proceeding resolved Mr. Gillespie's allegation without any finding that petitioner's pregnancy or abuse reports were false. His assertion of false pregnancy and abuse allegations in 2021 has no judicial support and is contradicted by 3 protective orders issued in petitioner's favor. Petitioner has 3 orders against Gillespie. Maricini's witness list describes Gillespie as a victim and claims petitioner engaged in retaliatory misuse of protection orders, which he's also claimed by a victim in Maricopa County. Mr. Gillespie did not even...
Mr. Gillespie did not even meet respondent until 2024. God. He lacks personal knowledge of any fact bearing on petitioner's current apprehension of respondent Maricini.
Idiot. Mr. Gillespie's credibility is fatally compromised by his extensive adversarial history with petitioner. For more than 2 years, he litigated against her in Owens versus Gillespie, advancing the same false pregnancy, forged ultrasound theories the Arizona court ultimately dismissed for lack of proof. That prolonged and acrimonious litigation, coupled with his repeated attempts to attack petitioner's character, demonstrates a continuing personal animus. I'm being... Were your ears tingling? Being rage baited right now. Oh my God. This history gives Mr. Gillespie a clear and ongoing motive to retaliate against a protected party by attempting to relitigate discredit allegations to this court. Such hostility falls squarely within Evidence Code of 780. Accusations of forged ultrasound, false pregnancy, or fraudulent pattern constitute inadmissible character evidence and are based on hearsay rather than first-hand observation. They serve only to impugn petition's character and are properly excluded. Admitting testimony grounded in disproven or irrelevant Arizona allegations would mislead the court and cause undue prejudice to the protected party. Any minimal probative value is outweighed by the danger of unfair prejudice, confusion of issues, and harassment. Oi. Claiming there's no pattern of behavior and then arguing that their participation in cases material similar to this one feels a bit... Oh, hi, Charlene. Well, I hope you get that fixed soon. So we want to include its entirety, okay? Preclude respondent to any alleged false pregnancy, forged ultrasound, or misuse of protection orders. Okay, I really need that.
I really need that to come out of there. I can't. We got to get that out of there. Also, I don't need any testimony about my charges in Arizona because that's really going to work against me. And if you could just grant whatever other relief that you see, necessary, that would be great. I would love that. Thanksies.
Because she evaded service, right. So who is this? Exclude witness number 8? Oh, this is her friend. Whoever redacted it here did not redact it here. All right. Sworn declaration filed 7 years ago, and to assert that the 2018 order was obtained by fraud. What? What? This is your one and only friend. Tell me more. Wait, tell me more. Tell me more, tell me more. Like, does he have a car? We would do what we can do, all right? I'm starting to think Laura isn't a very good lawyer. Listen. She's trying her best. She's trying her best. Such evidence is legally irrelevant. I'm sorry? Such evidence is legally irrelevant? What? I think that would be highly relevant because that would state that you don't need the renewal because you didn't actually need the original one. A hearing on a request to renew a domestic violence restraining order is not a retrial. Okay, great. Because blank testimony concerns authorship of a 2018 declaration, not current risk. The original one. Her evidence is
It's irrelevant. It must be excluded.
On March 29th of 2018. The declaration bears her handwritten signature, and the jurat, I declare under penalty of perjury that the foregoing is true and correct. Hold on a second. Hold on. Are you trying to say that she declared perjury while you are currently at this time being charged with 175 counts of perjury? What? Oh boy. Okay, and then all this is redacted. Why is all this redacted? I want to read it. I want to read it. All right. So I need you to exclude this because it all works against me. Oh, wait. What is all this? To exclude irrelevant and improper exhibits. Under advisement ruling from the Superior Court of Arizona issued by Judge Julianne Mehta, out-of-state minute entry in unrelated litigation contains no findings regarding petitioner's relationship with respondent Maricini or her present apprehension of abuse. Criminal indictment. An indictment is an accusation only. Okay. Doesn't matter that I have 14 felony counts. That has no evidentiary value. You could indict a ham sandwich. And that is in fact what I am. This is an attempt at witness intimidation. Why? Because she puts all their names in there. Correspondence from Dr. John Chung Kai Chan. Purported medical correspondence predating the restraining order by 2 years, not part of the 2018 or 2020 court record. The document is remote, unauthenticated, and irrelevant to petitioner's current apprehension of abuse. Good Lord. Matta was in 24, not 25. Great point. Hi, Maddie. Makes me think of Arrested Development when George said he may have committed some light treason. Yeetus, that fetus. Never gonna give you up. Never gonna let you down. Correspondence from Dr. Rebecca Yee. Like Exhibit 103, this purported letter precedes the original order, which is why I'm so afraid of him, because none of this shit was real. San Francisco police report and photograph of investigating officers. Police record from 2018 relating to third-party investigation not linked to respondent Maricini and not part of a domestic violence record at issue. The photograph is cumulative and lacks authentication. Weren't they outside of your apartment after you screamed at him in the streets and then he called the cops on you and somehow you were able to get an Uno reverse? Image of Laura with redness around her face, particularly her right eye. Undated and authenticated photograph offered without foundation. Wouldn't you want that one? You don't want that one in? You don't want that in? Of physical abuse that you stated was from him? You Q-tip. Digital forensics report completed by John Berryhill. Privately commissioned, unsupervised. I like to think of Brad as unsupervised. Just running around in people's computers. Just like when they have those fucking on those videos. It's like Brad just unsupervised. Hacking cases. I love it. Objection, Your Honor. Yeah. Did she use that? I don't know. Petition for order of protection against Clayton Ray Eckerd. Filing from separate Arizona case with different respondent. This has no relevance.
Your Honor, it has no relevance that I have 3 DVROs. There's a lot of men who don't like me, okay? I'm very scared for my life all the time.
Subpoena issued by the Superior Court of Arizona to Michael Maricini. This document purports to be Arizona subpoena. It was never domesticated through any court, and also she's going to say that it wasn't signed, so he can't come. Nana boo-boo. Respondent saying, or his counsel saying that he will not be testifying. And then he went on Megan's thing and said he knew he wouldn't be testifying, blah, blah, blah. Civil complaint against Greg Gillespie. Super spy Greg and Brad on the case. Have you guys ever seen Big Hero 6? The one guy that looks like Shaggy from Scooby-Doo, and he has no like superpowers, but his name's Fred, and he wears a big suit, and that's how he sings. Super spy Greg and Brad on the case. Hearing as to whether my fears of future violence are reasonable should in no way permit any discussion or consideration of reasonableness to those expectations. Okay, gotcha. Cool. Court would have taken judicial notice. It's coming in. She put all this stuff at issue with her reply briefs and sworn declarations, making it relevant in these proceedings. Oh my God. How could I resist? Low. Can everyone else hear the long sighs before and after each other? He's just like, type. I have to mute myself. I really do. One day, when she's in jail, listen, when she's in jail, you, me, I'm going to wear a collared shirt with an undone tie, and we're just going to talk all the shit, okay? All right. Deal. This is an unrelated civil filing from 4 years ago involving, again, somebody else. So, suck it. Petitions for orders against Greg. Out-of-state protective orders against a non-party.
You see, Judge, I have a map in my house, and I'm trying to get protective orders in every state. And when I get a protective order in that state, I color it in with a glitter gel pen. It's real fun. I like it. It's like I'm collecting them.
Loop. Ugh. Oh, God. Positive pregnancy test by Laura. This is an unauthenticated photograph or record predating the issuance of DVRO by 2 years. Irrelevant to current fear. It's unauthenticated? Why wouldn't you just say this was 2 years before I got the DVRO? It has no relevance here. This has nothing to do with the DVRO. But you said unauthenticated photograph. What could prove its authenticity? You? I don't know that fear. It goes to another school. Text message by Laura claiming concerns of a miscarriage. Text message by Laura claiming concerns of a miscarriage and on her way to the hospital. Text messages by Laura claiming her twins' pregnancy was no longer viable and that she would take abortion pills. Text message by Laura Owens claiming that the abortion pills did not work. Dude, the way I can see smoke coming from her ears while she's writing this, it's my favorite thing. It's my favorite thing. I love it so much. All these messages. Let's see. Why does this do? I hate that this does this. It pisses me off. All these messages predate the 2018 restraining order by several years. These are whole mention, unrelated to the statutory question of current fear. Each is unauthenticated, so you can't prove that they're factual. They are remote and inflammatory. How are they inflammatory? They're your text messages, dipshit. I just realized that it took Laura and Jan 11 months to contact Napkin Lady. Interesting.
When I get all 50 states, my mom says we can go to the House of Prime Rib.
She has this many positive pregnancy tests. Oh my God. Facebook post of Laura at KGO celebration for Ron Owens. A social media post with no connection to alleged abuse or current apprehension. Would only serve to harass. Even though I claimed to be pregnant, it's a... this is a person. This is a pregnant person. Do you know how hard it is to draw with a mouse? This is a pregnant person. It's a dog line. Sad. It's still a dog line. My actual side pregnant. That was also me. I can't draw with a mouse. Do you know how hard that is? God. But anyways, I have to give the people... Wait. That's going to make it so much better. Okay, so you see, I was at this bar, right? And I was with my dad, Ron Owens, over here. Here's Ron. Right? And we're at this party. Hooray! But they were mad because I said that I was pregnant, but I had a drink in my hand. And Omar was like, that bitch be drinking while she's pregnant, which is bad. Okay, I know how I'm reading these documents from now on. Wait, are they on a football field? Why are they on a football field? These fucking comments are frying me. The fuck? Holy shit. Oh. Oh. I just bought waterproof mascara. It's L'Oreal Telescopic. Let me tell you, it works, girls. It works. Shut up. AJ, goddamn it. Everything is fine. Make this the thumbnail. It tells a story. Make it a double. All right, we'll give her 2. Oh, God. What the fuck is this, Tiff? There's a new filing in the criminal case. Ugh. All right, where do I find that? If I get a touchdown, do I have to say... What's on her head? Her hair. This is her I don't know why. This is fine. This is so stupid. The like I have to tell a story through pictures. Where is her TR? Right here. It looks like 2 martinis. I don't know how to draw a double. You got me giggling. We're missing. We need crumbs. Where? Here are the crumbs. Oh my god. That isn't a stick figure frog on her head. Oh my god. Oh my god. All right. All right. Oh, Ron's walker. All right, hold on. Wait. Is this walker? I can't with this stupid fucking stream. Fuck you guys. Give it wheels. It's not a toilet. It's not a fucking toilet. It's a chair. It's a blank chair. Oh, okay, wait. Where's Frosted Flakes? My stomach hurts so bad. Nay. It's not a dog. It's a horse. It needs a saddle. Okay. Here's the bridle. I have tears. My makeup is gone. Oh god. Looks like a horse, not a pony. That's a mighty fine horse trying to ride And he jumps over hurdles. But they're only 3 feet. That's an F. 3 feet. And here's a third grader that's like, oh shit. Scared. Oh no. Here comes Laura Owens. Please save this. It needs- Oh my God. This is so stupid. You can lease that. Oh God. Oh, somebody clip it. I don't know. This right here is my favorite. I want to make that my profile picture. All right, hold on. I'm screenshotting it right now. And then we're going to put it in the Discord. Every motion now, from now moving forward, has to tell a story. Trying to work. Oh my God. Only 2 feet because he only had 2. What? Oh. I thought you meant the real horse. I need to buy Adobe. This isn't Adobe. No, you can do this when you download PDFs in Google. You can just do this. But shut up. In a filing somewhere. With stuff. Sammy, just buckle up. Sorry, I paused to get a screenshot of the glorious. Oh my God. All right. I am a serious streamer. I am a serious true crime streamer. Ron is my favorite. We could just have Bacon do this. These are just going to be my thumbnails from now on. Put a fiber watermark. Fiber. I need a new color. Fiber. I know it's like multiple. Ew. Fiber. Now draw the YouTube as a pinball machine. Yeah, just send me all the fresh water. You could auction it off. I'd buy it. $3. $3. Oh, okay. Ron is my favorite. I love him. He's so cute. All right. Hold on. Somebody sent me something serious in the that's me. Hold on. Somebody sent me something serious in the Discord. All right, everybody take a drink. I'd give you $2.50 for it. I'd give you a fake ultrasound for it. All right, let's go to these motions. It's not getting. All right. This isn't in Google, so I can't open it and draw on it.
Friday Steam, you have to draw everything the chat says.
Can I at least use my pen, or do I have to use my mouse? Hey, Michelle, Michael? Michelle? Yes. So you should be able to get it in YouTube. You should be able to get that. Hold on, let me open this. It should have it. All right. If you open in Google, Tiff, you can draw on whatever you want, okay? You can do it. Yeah, let's bring back the art stream. Mouse only. Oh my God. I would have run to the bathroom by now. It's going to be soon. It's going to be soon. All right, so who is this from? The Guardian Law Group. Guardian Angels. Guardian. Ha. If you can't get it, message me on Instagram and I'll send it to you. Oh, Lord. I'm unstoppable now. Christian, I'll be ready for trial. Looters once a 90-day continuance. You guys, whatever. These are my favorite days. Every day is my favorite day. Oh my God. All right. So we have the state of Arizona versus Laura Michelle Owens. Bad. Defendant Laura Owens, by and through undersigned counsel and pursuant to Rule 8 of the Arizona Rules of Criminal Procedure, respectfully requests this court to enter an order continuing the final trial management conference for tomorrow? How the fuck are you going to put this in today? More snorts, please. Shit, the art is back. How are you going to put... She's supposed to have it at 8:45 tomorrow. And respectfully, for 90 days. No, wait, that's bad. I don't like that. Wait. It's mad. Oh, God. We'll move if we need to. As soon as the expert request came in, it was going back 3 to 9 months, depending on a decision. Okay. The state represented by Edward Leader was consulted and has no objection. The new filings is that she's supposed to be in court by tomorrow, but she's asking for 90 days. Just 3 months. So let's see. So that'll be October 22nd. That's my daughter's birthday. Filed yesterday, docketed this morning. Come on. Come on. You knew this was coming. Discovery is complete and defendant's discovery review is ongoing. The parties are also in the final stages of plea negotiation. Yeah, what's that? Because they said it would be jail time. Jail time. Jail time. Here's Laura sad in jail. Oh. Have her hands wrap around these bars. Sad. At the previous complex case management conference, the parties discussed several issues, including setting a realistic trial date in late October and scheduling a settlement conference in this division in late August at the time. The proposed date was 8/26. Okay. Okay. 90-day fiance. She's out of here. She's out of here. In addition, defendant was recently granted indigency status for the purposes of retaining the assistance of an expert in the area of digital forensics. Brad, is that you? Are you the expert in the area? The idea that Lowe would actually accept a plea deal, I feel super bad for the guys. Right. Last minute, how you win it. Ugh. The additional time between now and the proposed settlement conference date will be used by defendant to retain said expert and prepare a mitigation. For what? Also, why does the prosecution have no objection to this? Especially at this time. The request settlement conference will likely represent the plea deadline. And the parties believe that a trial date in late October is realistic. No, it's not. No, it's not. The judge can say no. Plea negotiation status aside, the parties require additional time to prepare for trial. Therefore, because the current trial assignment date is unrealistic and extraordinary circumstance exists, like what? Defendant requests that this court continue the final trial management conference and trial assignment date for 90 days and extend the last day accordingly. The parties also request that the court schedule a settlement conference at its convenience. Defendant waives any applicable time pursuant to Rule 8. Unbelievable. Yeah, the parties are agreeable. Yep. Not I. Didn't we know this was coming since the plea deal was extended to the end of August? Nick Starro! Santa Claus Raid. Hello, everyone. Hello, everyone. If you are new here, my name is Bacon Bearzz. We are currently talking shit about Laura Owens and everything. Also, I don't know if you know this, but I am an artist. So this is what I do. I'm a very serious true crime commentator. This is Laura Owens pregnant at the bar. This is her double martini that she's having. And this is Ron Owens over here. And this is her horse Frosted Flakes. I mean, I know you could tell that by the picture, but just in case. Damn it. Hey, Steve, how are you? How are you? Anyways, me, Raid. Nick Starro, what did you cover today? Also, Nick, I just want to let you know, because I haven't talked to you in real time. I would like to let you know that you are actually on my hit list. Where are you? Right there. You are on my hit list of people to collab with. So we're going to need to come up with something. The people want it, okay? So you talk to me, I talk to you. He's in the black chair. The black chair! I have to invite you to my Slightly Buzzed show. I would love that. I would love that. Let's do that. Behold, our local art. Support local art. Oh my God, you listen to the audio. How's your blood pressure? Is it good? Ugh. I know they're normal, but he was like, we don't even need it. He was like, we don't even need the first one. This could be on a shirt. I'll put it on a coffee mug. Oh, Princess, thank you. I'm Great Bacon. New documents coming in the DVRO case today. Stay tuned as I'll get them around lunch. Send them to me immediately. A hit list can also be interpreted very different ways. No, I know, but it's for our collabs. Yeah, I'll do it. Let's go. MG Laws is in here. We love it. The black chair will catch him when he tries to use a two-legged walker. Oh, God. The John O'Keefe crime scene. Oh, my God. I need this on a mug and hoodie. You got it. You got it. Hi, Lana. All right. Well, print that page of the motion framing. I already screenshotted it. I think it's in the Discord, honestly. Ugh. So we're reading the fact that she wants to, hey, Colorado Canadian, thank you for that goat. Can you quickly go over the extension request? So I just did that, but I will do it again. So she filed it yesterday. It was docketed today because they have the extension, or they have the trial meeting tomorrow. She wants 90 days. Yes. Okay. So we will, okay, I'll put this on a shirt. I'll put it on something. Let's go over it again in real time, just so we can talk about it one more again. Where's my downloads? Here we go. All right. Just so you guys can get it. This is new to the docket. Thank you, Big Tiff Dog. All right. So they currently have a conference and trial assignment date due tomorrow at 8:45 a.m. Okay? Tomorrow. This was docketed today. Now, they say discovery is complete. The defendant's discovery review is ongoing, and they are in the final stages of plea negotiation. But whatever. At the previous complex case management conference, the parties discussed several issues, including setting a realistic trial date in late October. I see it for March. I don't see it happening in 2026. And scheduling a settlement conference in the division in late August at that time. The proposed date was 8/28/26. In addition, defendant was recently granted broke status for the purpose of retaining the assistance. Hey! Oh, we will do it. We will go to trial. Of an expert in the area of digital forensics. She needs to retain the said expert and prepare a mitigation. The settlement conference will likely represent the plea deadline, and the parties believe that the trial date in late October is realistic. I do not. I do not at all. Hi, Ghostery. Plea negotiation status aside, the parties require additional time to prepare for trial. Therefore, because the current trial assessment date is unrealistic and extraordinary circumstances exist, ? Like what? Because Christian said before the first plea deadline that he wouldn't even need it. He wasn't even going to need it. Hi, Chris. Defendant requests that this court continue the final trial management conference and trial assignment date for 90 days and extend the last day accordingly. Boo. So 90 days from today is going to put us in October. Hold on. So 90 days is October 22nd, right? About 3 months. So what's this? July. So August, September. Yeah, it'll be October. So how can you have a trial set in late October if that's the time that we're going in for the settlement conference? Anybody?
Question mark.
All right, they want the song, they'll get the song. Because that's what we do. We tell Laura to go to trial, Laura Owens.
Nope.
Do it, do it.
I don't wanna.
We believe you.
Okay.
Tell your story.
I will.
Go to trial.
All right.
You're not a liar.
I know.
We believe you.
Okay.
Do it, do it. Hey, Laura Owens.
That's me.
Go to trial. We believe you.
Bet.
Everybody else is lying. Go to trial. Laura Owens, you can do it.
Yes, I can.
We believe you. Ugh, God. This was supposed to happen in January. I know. Oh, my God. All right. Well, looks like I'll be sitting here doing this for the rest of my foreseeable life, friends. This is what I do now. This is who I am. Okay? This is who I am. Whatever this is who I am now. So, oh, God. I think Christian believes he can get her to take the plea based on his experience. Yeah, there's no way. There's no way. The conference is the end of August, the 28th. Okay, and they want to be ready. But then, no, she wants a 90-day extension for the trial? I'm so confused. Oh, if she can ask the attorney. Yeah, I don't know. That would be a question for After Hours. After Hours, can Jennifer ask her lawyer who's paying her? Is absolutely chef's kiss. My delicious crispy McDonald's Coke just sloshing around my belly. I'm surprised she stayed this long, honestly. Oh, they can. Okay. The answer is yes. So. Brad is in the chat. All right. Back to this. If you guys like super serious reporting and you are new here, please hit the subscribe button, hit the like button, mash your face against the keyboard. So, Equestrian rider reports during 2016. This is unrelated business or recreational documents from 9 years ago. Irrelevant to abuse or fear. Petition for order of protection by Greg. Filing a third party in another jurisdiction. Irrelevant to current proceeding. See, Greg. This is Greg. He lives over here. Laura moved over here. So you can't have him here. Do you see? It's math. It's math. Serious reporting and art. Longer legs. He doesn't do leg day, okay? Hmm. I like it. Picasso. Discord. Show me. What's in the Discord? What do we have? Oh. Brad messages me with the motion continue in giant letters. Here, quit your laughing. It's serious business time. The trial is pushed for 90 days. If a settlement conference is fruitful, then trial not needed, but at least it's pushed out. Okay, so we're looking at trial in October. All right, listen. I never said I was smart, all right? I just pretend to be. I'm still recovering from yesterday. Oh my God. Yeah. Thank you. Thank you, everybody, for coming. I appreciate you. Thank you. Grab your drinks. Tip your waitress. Geography, math, physics. We got a lot of fun. We have a lot of fun here. I do want to go on the Slightly Buzzed podcast. I don't know what we'll talk. Well, we'll talk about Laura Owens, I guess. But thank you, Brad, for being smarter than me. I appreciate you. Thank you for that much needed dance break. Phrasing. What is it? All right. Text message from Laura Owens to Michael Maricini stating she loves and trusts you. A single?
One single text out of the 8,000 that I sent him every single day from 9 years ago, even though I was sending him those text messages now, but I can't because I have a DVRO because he didn't want to date me, is unauthenticated and irrelevant to current fear.
Bring your bevies. Oh, God. Tip your drinks. Text message from Laura Owens stating, I love you. Horny baby. So this is her holding her air puff bean blaster. And here's the TV. Here's Tony Robbins. Everybody loves Tony Robbins. Confetti, confetti, confetti. And here is the beehole. I'm somebody's mom. And some tunes. Oh my God. Why? You guys, I have kids. I'm responsible for other people. Splash. Pew, pew, pew. Oh my God. And then there was an email from Laura's attorney. An email from Laura's attorney to David Gingras. This is legally and factually incorrect. All right, we have these. Yeah, it's a breathing potato. What? Pointing at herself. Email to media tip regarding Clayton Echard. Media correspondence unrelated to Maricini or current fear. Hearsay and prejudicial. State's notice of disclosure and request for disclosure filed by the state of Arizona. Criminal discovery filing from separate jurisdiction irrelevant to this renewal. Text messages by Laura regarding inpatient psychiatric theory. Private health-related communications outside of the scope of the proceedings. All right, here's Laura. Here's a hospital bed, right? She's just laying here with a straight jacket. Except she's not actually in a house, or she's not actually an inpatient, because here's Jan taking the pictures with the phone to show that she's an inpatient. Pew, pew, pew. Right? And here's, yeah, Jan's like, oh, yeah, that's it, honey. Take that picture. Why are they all melting? To contemplate a PTO. Oh, my God. Declaration of Laura Owens. Declaration already contained in the 2018. Cumulative and redundant. Everything you fucking say is redundant, dumbass. You doing? Oh, yeah, I forgot about it. I was going to put a cigarette in there. You're doing great, honey. Little orange on the end. No, I need an orange. We need orange. Right? And then like a little smoke. Need some smoke. You're doing great. You're doing great. I love it. It's competing with Banksy street art. Oh, God. What's really funny is this screen that I have is a drawing screen. So I have an actual pen. But doing it with a mouse is so much better. Finding after trial by Judge Matta. Out-of-state ruling does not count. So, nana nana boo boo. Petition to court, order paternity filed. Who's Margot Martindale? Margot. All right, I'm getting my karma. I almost choked. Oh, yeah. For Jan? Sure. Yeah, she's great. Somebody said Kathy Bates. I could see that too. Megs Bennett. Yeah, I've never seen that. Oh my God, she was married in 1986 and they're still married? I love that. That's awesome. Referee out of bounds. That's how you get pregnant with twins. Knew it. Oh, no. Wait a second. Did I just close my screen? Oh, no, it's still there. Okay. I was going to say all my hard work. Petition to court order filed paternity. Filing from Arizona paternity case against a different party to Nexus respondent Maricini. Okay, so if you guys don't know the story, here's Laura Owens. She's pregnant with 2 babies by a guy who I don't know if you knew was on The Bachelor. I'm Bachelor. I'm The Bachelor, right? And this is in Arizona. Mike, evil Mike, is all the way over here, Arizona. And he's scary. And that's why these two can't be together in the same thing. And that's the last page. The end. Tonsillitis, tomato, tomato. Not pictured Greg because he is ninja couple potatoes. Put a rose in Clayton's hand. Oh my God. You guys don't worry. We'll have 18 more years of this. Master hack over here. California, not. Oh, that's right. California, not Arizona. Who cares anymore? Where are we? Like a party. Dave, protect our bacon, please. Please. Clayton gets a wilting rose. Okay, so in an effort to avoid cross-examination, Laura files something else. Laura files an expedited request for reconsideration of motion to continue. In it, she claims to have new medical evidence, a letter from a nurse practitioner stating attending an October 21st hearing would be life-threatening for Laura. Laura asked the court to grant the continuance to allow for medical stabilization and recovery. LJK just texted me. We need more art. Don't worry. You want it? I got it. All right, here we go. Pregnant with lies. So this, I hate that it does that. All right, so this declaration of Laura Owens in support of expedited request. Great. Allegedly, maybe. Allegedly, maybe. Laura Owens declared as follows. I am the petitioner in this matter. Me. All right. Since the court prior denial of my motion to continue, I have obtained new medical evidence. That was fast. Exhibit A is a letter dated from October 17th from Dr. Colleen Green, a medical provider I've been seeing since September of 2024. This would be life-threatening for her because of a psychiatric and physical decline. Downward. This new evidence, unavailable, the court previously ruled, directly rebuts any assumption that I am capable of safely participating in a contested proceeding at this time. So, yeah, right, basically. Bulbas. No, I was drawing a pregnant lady. Listen, I tell my story through art now, Rachel. Potato babies. In addition to Dr. Green's findings, my other treating medical providers have diagnosed extreme anorexia following a 50-pound weight loss. Height, 3'7". Weight, approximately 84 pounds. Accompanied by gastrointestinal bleeding. Although, let's not forget, in one of her Medium blogs, she said this was the goal. Big bulbous. But I'm healthy enough to ride a horse. Exactly. Following multiple episodes of vomiting blood, which looks like this, my treating physicians advised that urgent gastrointestinal testing and specific evaluation were medically necessary. I was referred for a specialist consultation scheduled October 22nd, which is the earliest available date for the required procedures. So hold on, wait. When is this? When did you file this? When did you file? I need to know when this was filed. 10/17. You're vomiting blood. And they're just like, you can wait. You're fine. You're cool. Pull over, for Christ's sakes. God. Postponing this appointment could delay essential diagnostics for several weeks and significantly increase the risk of further bleeding, worsening anemia, and medical destabilization. Okay. So today is October 17th of 2025. The intervening weekend, 18 and 19, leaves no business days to notice or calendar an ex parte application. There is no practical opportunity for a hearing or oral arguments before the scheduled dates. I therefore respectfully request that the court rule on this request and on papers pursuant to its authority under California rules and San Francisco Superior Court local rule. Frosted Flakes was worth Yeah, and in their bankruptcy, she's like, we leased Frosted Flakes. And I was like, we've been so poor, we've also leased Frosted Flakes, bitch. And not even the cool ones, the ones that they sell at Aldi. The snowy flakes. Interpretive dance. Oh my God. This request is made in good faith, everyone. Thumbs up. And not for purposes of delay. Never. I am asking only for sufficient time to stabilize medically and to participate safely in horseback riding. There's a tiny horse. Whatever. Once my treating professionals determine that I am doing well and no longer pose a life-threatening risk, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Yeah, we know that perjury means nothing to you. Yeah, if it was life-threatening, she'd be in the hospital. Your mama's so poor she leased Frosted Flakes. Let's bring back Yo Mama jokes. I love it. 4 fingers, bacon is clay art next. Oh my God. Good Lord. Dear Diary. Can you believe it? I was sick, or I said I was sick, and they didn't even send a GoFundMe for me. How dare. Dude, where did my Volo screen go? Hello? Declaration of law, free silly songs. There's, all right, I guess I just, am I done? I don't have Volo anymore? The fuck? Nope. All right. We love your energy. I love you. Yeah, right. Under penalty of perjury. Ugh. Laura seems like she would be as a hypochondriac under regular circumstances, but I also feel like she would absolutely be a drug user, so I don't know. I don't know. My mom is so stupid, she didn't even know what she submitted to feds for the day before. My mama's so dumb. She thinks she's getting in on the action.
My mom is so broke she doesn't know the difference between gross and net income. Wait. Oh, that's my mom. Shit.
Oh, God. Okay. Let's get down to business. You guys, I'm so derailed from that stupid picture. I don't... Oh, my God. Your mom is so stupid. She went to Saks and ordered a... I say that all the time and nobody gets that reference.
Hello, shoe store? I need the soles. Give me the soles.
And she ordered... what is it? A Nikoi salad instead of a Niçoise salad. Yo mama's so dumb she doesn't even know who's paying for your criminal attorney. Oh, God. Yo mama's so dumb she thinks GoFundMe pays off Macy's credit cards. To the point of describing multiple conflicting statements. I know. All right, so we have that as supporting her evidence through this request. The request was not granted. We stand a competent judge. So fucking done with this family. I think she's gonna hit Jan with some perjury. Why does she need 4 different names? Why does she need anything that she does? I was gonna type that out and I was like, wait, how do I spell that salad? Nikoi salad? Yo mama's so dumb she thought perjury was a medical diagnosis. Wait. You guys are getting new Jan. Hold on. Yeah, hi Sarah. Yeah, how's it going, honey? Sure. Of course you're still my favorite. Shut up. Shut up. Don't tell Laura. If you tell her, I have to kill you. Listen. We're not going to be able to come over right now. She's got a case of the Bearzz. Yeah, it causes like explosive diarrhea or something. Yeah, the Bearzz. Yeah, that's what the doctor said. Under penalty of perjury. Yeah, it's a diagnosis. She's got perjury. It's so unfortunate. I hate it. Just makes her shit all over the place. I'm gonna have to take her to the hospital. Then she's gonna stay there. They're gonna be like, you don't have anything. But we know she's got a case of the Bearzz. She's got 14 of them. It's wild, I know. It's crazy. She's got perjury. Oh my god. She's got a case of the Bearzz that makes you shit right out of your mouth, you know what I'm saying? But I wonder if the perjury is what... no, I don't think so. What the frick? She's got a case of the Bearzz. She's got it bad. Oh, God. I don't know. Jan might be one of my favorite characters. Jan is the Italian mob boss. Laura just is delusional and thinks everybody's poor. It's crazy. So on 10/20, Rachel, I'm so happy you are here. If you guys didn't know, Rachel's actually my best friend in real life. We've been best friends since we was 10s. We've been best friends since we was 10s. So it's only 30 years of friendship. Hey. So Laura Owens via a friend of the court. Who's a friend of the court? That's also a friend of Laura Owens. Nobody. Ever. Who? Lawyer offered Maricini several versions of a settlement, including a non-disparagement clause. Knowing that this was a blatant trap, Maricini declined, offering a counteroffer. If you drop it, I drop it. We're your best friends. We're your best friends now. A friend of the court is like a friend of ours, capiche? Oh my God. In the early evening hours. Oh, this is so dramatic. Drama, girl. Give me the drama. In the early evening hours, Laura accepted this offer. However, less than an hour later, Laura rescinded the offer and stated she planned to move forward with the trial the following day. It was clear Laura planned to appear virtually rather than required in-person attendance. 10/21/2025. Michael Maricini and his legal team, Omar Serrato, tie undone, wind in the hair, walking slowly into the courtroom. Behind them, Rachel Juarez in a power suit. And then an explosion happens. They appear in person for the first day of trial. Laura, however, appeared virtually. Judge Gold made it very clear to Laura that in-person attendance was required, not suggested, as there was no reporter that day, and a second day of trial had been previously allotted for. Does he look like Fabio? Do you have informal conversations about GoFundMe scams. We have informal conversations about people we know who are scammers. So, yes? Judge Gold ordered to convene the next morning. The court issued mini minutes to recap the hearing. All right, what's in the mini minutes? All right. Matter is on the calendar. The court notified the parties that there is no court reporter available. Court admonished petitioner because she had to be there. So you better be there tomorrow. Mini minutes. Narrate the future docuseries. Let's do it. Let's do it. Who's leaving? Ugh, you have to go to work. Quit your dobs. Your dob. Quit your dob. So many minutes. Minutes, right. Many minutes. Michael Maricini hires a court reporter. As trial was set to begin, Laura was absent from the courthouse. 20 minutes after the scheduled time, Omar Serrato and Michael Maricini were called into the courtroom. Laura Owens appeared virtually. Laura had made an emergency ADA request. This pisses me off every time. Which necessitated an immediate continuance. Laura claimed to be experiencing life-threatening illness. She alluded 2 weeks prior with a smirk from Laura. The hearing ended, and a new trial date of November 5th, 2025 was set. The court's mini-minutes recap hearing, an order reschedule hearing to renew the restraining order was filed by the court as well. So for those of you who don't know what ADA is, does it explain it in here? I just don't want to get it wrong. It's accommodations. It's her request for accommodation. The court acknowledged that she has to have it. She has to be required to have it. So she requested accommodations. I wonder if those accommodations are for her eyebrows. I'm just wondering. So I can be if you're Laura Owens. ADA requests are not an emergency. You know in advance. You make requests long in advance because you know what you need. Well, yeah, you know what you need until the judge doesn't give you your way, and then you're like, shit, how can I do this? This is allowed. Oh, Americans with Disability Act. There you go. Right. She's like, this is when she starts having disabilities. Maricini's legal team becomes aware of yet another ADA request, and continuance have been requested by Laura Owens. Judge Gold denies the request. Laura Owens files a bar complaint against attorney Rachel Juarez. How dare! Laura Owens files a bar complaint against attorney Omar Serrato. What? The court notifies both parties that it's a high likelihood no court reporter will be present for the following day's trial. Sometime before 5 p.m., Omar Serrato, with a last-minute buzzer beater, alerts the court that they've secured a court reporter, one who is certified and approved by the court. Laura goes on to state that she does not consent to this certified, court-approved court reporter, fucking idiot, and that she had planned on not coming to the hearing. Laura sends several emails to the court stating she suffered extreme vomiting that has necessitated a visit to the ER and a potential procedure under anesthesia, and would therefore be unable to attend that day's trial. Maricini and his legal team appear in person for the hearing. Laura is absent. Judge Gold, due to Laura's required appearance, which was not adhered by, dismisses the DVRO request. Inside Edition publishes a video interview and a story about Laura Owens and lies relating to Michael Maricini. Interviewed are Michael Maricini and Rachel Juarez. All right, well, let's watch that shit. Let's see. Omar, I think, covered this on the podcast. This stuff just gets granted. They don't have with it in Cali. Right. No one asked for your consent. Spontaneously conceiving fake twins, and yet Omar has not been sanctioned by the bar or charged with any crime. Imagine that. We are so close, people. I can see the promised land, the land of the When does The Bachelor come into play? We're going to watch The Bachelor? And then the sun came out. Oh, God. A procedure under anesthesia where all the doctors had to listen to Lowe in a doctor's office. So they made themselves pass out. All right, let's watch this.
This man says he's been living a nightmare after the woman he dated falsely accused him of fathering twins.
For the last decade, it's been a miserable experience.
Michael Maricini says he met podcaster Laura Owens in 2016.
Podcaster? I'm a podcaster. Unpaid viewers. I didn't buy them. I sucked them in and then I grew on them like mold.
My name is Laura Owens.
After 2 months of casual dating, Michael says she told him she was pregnant.
Did you think that there was any way you could have gotten her pregnant?
I had major doubts because we had only had protected sex.
Was there anything unusual about the pregnancy?
There were twins.
He says Owens bombarded him with fake pregnancy tests and photos from a clinic after claiming to have had unsuccessful abortions.
I was petrified. I had a pit in my stomach for months. And the last thing I would ever want to do was have a child with her.
After 6 months of chaos, Michael claims Laura Owens finally admitted to making up multiple pregnancies.
Did you think that she was pretending to be pregnant to keep you in the relationship?
I did.
According to Michael, after he broke up with Laura Owens, he says she came up with a new story that he had abused her. That claim totally upended Michael's life.
She said that I had strangled her, that I had taken her within inches of her life, that I had beat her on a regular occasion.
Were you ever physically abusive?
No.
Did you ever threaten her?
No.
Michael says they were all lies, but Laura Owens obtained a domestic violence restraining order against him. Michael's wife, Danielle.
We've spent many nights crying because we just felt powerless, helpless.
They say the restraining order ruined job opportunities and Michael's reputation. Danielle says she was too scared to post their wedding photos from 2 years ago, fearing Laura Owens' reaction.
I felt fearful that she may come harm me. She's just so unpredictable. You don't know what she may or may not do.
Yep.
But Michael wasn't Owens' only alleged target.
I'm dealing with the most crazy individual I've ever met in my life.
TV's former Bachelor, Clayton Eckert, recently...
The Bachelor? Did you guys know The Bachelor was in on this? The Bachelor?
Went public with his own battle with Laura Owens. He said, like Michael, Laura Owens accused him of fathering twins, but a judge said that she lied.
We ask that you keep us in our thoughts and prayers.
Now, Clayton, Michael, and another alleged victim of Owens, Greg Gillespie, are teaming up, issuing a public warning. They say that Laura Owens has a pattern of falsely accusing men of impregnating her with twins that never exist.
Laura, Scottsdale Police.
Another jaw-dropping development. Police served a search warrant at Laura Owens' home in Scottsdale, Arizona. She now faces 14 felony counts, alleging she committed fraud and perjury against Clayton and Greg Gillespie.
Don't make fun of her diagnosis of the perjurers. That's very serious. It's very serious. Don't bring up her diagnosis.
Don't understand!
Attorney Rachel Juarez from the court TV show
Yeah, Rachel
represents Michael Maricini.
Sorry,
when
that was
her
loud.
pregnancy claim doesn't work out because no baby comes, she resorts in a lot of ways to restraining orders. I've never seen anybody do something like this.
This month, a restraining order against Michael was dismissed after Laura Owens failed to show up to a recent court hearing. She told Inside Edition she was hospitalized at the time with a severe medical condition and she couldn't make the court date and is appealing.
What, in your view, is justice in this case?
I think the only thing that will change her is actually going to prison.
Laura Owens has pleaded not guilty to criminal charges. She denies Michael Maricini's allegations and says she's telling the truth.
Good. Tell the truth in trial, bitch. Do it, we believe you. hospitalized with the perjury after the dismissal. Hello? After the dismissal of the phony DVRO renewal, Michael Maricini gives several other interviews, including with Megan Fox, Omar Serrato, and Lauren Knighty. Laura Owens, having been recently indicted on 7 more felony charges in Arizona for fraudulent activities concerning 2 other pregnancy fraud victims, bringing her grand total at this time to 14 felony charges.
Who else in the chat has 14 felony charges? Not you, not you, not you, not you, not you. Can't have them. Not like me. I got them all. And you know why you can't have so many felony charges? Because you're poor. So, they went after me big time because I am very rich and very successful and just very everything. So, sorry, you can't have 14. I am the best. You are the worst. I'm rich. You're poor. So.
And then she files a notice of appeal in the DVRO case, which we have already gone over. December 18th of 2025, Laura filed a designation of record on appeal to be included on the record on appeal from the November 5th hearing. Laura asked to include several things that were not on the official record. Good Lord, what is this? Oh, God. Finally, something she's successful at. Very everything. I've never had a case of the perjures. What are the symptoms? Things just fly out of your mouth. After things fly into your mouth, I guess. I don't know. Okay, so this is from Laura Owens. Okay, appellant designates the following documents, title by filing date. Request to renew restraining order. Oh my God, all of this. Okay. Notice of hearing, renew restraining order, order to reschedule hearing. Okay. Many minutes. Oh, so she's just, yeah, all right. So she's appealing this. Okay. So that's that. Good luck with that. Mysteriously disappeared because I ate them. I ate all of them. All right, guys, we've made it to 2026. And I still have time left today. Holy shit, we could be done with Michael Maricini today. All right, let's go for an epic finale, or at least epic something before I have to go potty. All right. Here we go. The cost for a copy of the clerk's transcript is stated in a filing to be $537, which I want to know how she got $537 to pay for this. 2026, February. The wildly successful podcast Love Trapped, Owens versus Eckerd. If you have not listened to it, go do it because it's incredible. Was officially released. Latter episodes of the series cover Michael Maricini's story and experiences with Laura Owens. On 3/19/2026, a notice that the clerk's transcript and reporter's transcripts on appeal have been completed and certified to the Court of Appeal was filed. 5/4/2026, Michael Maricini, via his attorney Omar Serrato, files a motion for attorney's fees and costs, which we read, and it was amazing, and he wanted $200,000. However, due to Laura's pending bankruptcy case and the stay in place, the fees and costs filing is withdrawn. Laura Owens has made it clear that she has no plans to end her abuse against Michael Maricini. Okay, and then there's something coming out today that Steve said he would have it. So let me open my Instagram just in case he can send it to me. But I think there's some papers in the appeals. So I will keep my my things open. But if anybody gets that, that would be great if you could let me know. And then we have the pregnancy timeline, all right, which is, hold on. Okay, we have all of this. Okay, so they did the timeline on that, and then we've read all of the documents. This is him refuting. Wait, what is this? She submitted a declaration in support of her request. Oh, there's more? What is this? Didn't I already read this? Hi, Jennifer. How are you? Oh, paid. Just put it on the Macy's card, honey. Oh. Yeah, I think I've read this. I just want to make sure. Laura claims Michael has been physically abusing her in June, just 3 months after meeting. However, in her Dasami interview, Laura Owens claims the physical abuse didn't begin until their trip to Iceland. Nowhere in her declaration does she mention being abused while being pregnant, nor does she mention while being abused while having ovarian cancer. Laura Owens claims it was Michael Maricini's decision for her to get an abortion. However, her text messages claim, okay. Laura Owens claims Michael Maricini pressured her to make an appointment in Planned Parenthood. Okay, yeah, okay. We've gone through all of this. The Dasami interview is the one that we watched with that doctor, I say lightly. Hi, Captain. Radio 1. Okay, we've read this. Okay. Yes, okay. We've been through all of this. All right. I'm gonna go to the bathroom, okay? But I still have another couple of hours. Hello. Ducky, hello, South Florida. Okay. We win. We are finally done with Michael Maricini. So, I need to know what we're going to cover next in this case. Here's about. I want to step away from the men for a second. So let's read about something else. Let's read about. All right, I'm going to leave this screen up. Okay? Hold on. I'm going to leave this screen up. All right? You guys chat while I go to the bathroom. And then decide what we're going to do when I get back. Okay? BRB. Be good, y'all. I'll put on some good music for you guys. All right, friends. What are we looking at? Oh, boy. I'm not a pooper. Easily distracted. All right, what are we covering next? What should we cover next? I want to get away from the men for a while, is what I think. So we could do either this or there's, because we'll get to Clayton. There's other victims. I know there. Oh, what are these? What are these?
83 on the second round course. That's a 165. Adjusted to the second spot here. 165, the total for CEO of 9.
Okay. All right, we'll go to the Justice for Laura website. That'll make me laugh. I haven't, you know what? I haven't seen her videos. I need to go check her stuff out. Dude, what is happening?
The 79 coming.
Wow. All right, should I pause it until it like is done buffering?
Back now. Here's
I'm gonna punch myself in the face. I have Ethernet. Humor is top notch. We'll get officially nothing done.
Koval and Laura Owens.
Yeah, Laura Owens. No, like my cable plugs in to the wall. I just got a whiff of banana because I'm playing it through another website. Where am I supposed to play it?
On the second round, 410.
Bro. Directly from YouTube? I don't think it goes to YouTube. It's just here. It's on their website. I don't know. Have you watched Gingrous Laura YouTube show where he explains the plot? No? You can download. I'm not downloading any of her shit to my computer. None of it. Oh, shit. Oh, shit. Damn. All right, while it's still buffering, let's just, watch it again. I want to know what happens. Like, the horse speeds up. I'm so confused as to what happens. I gotta tell you, if I'm paying $200,000 for her to keep falling off of horses, we're gonna pick a different activity. The crowd doesn't even. This is the one where she slowly falls off the horse. Why does it just go? We've seen this one. And then she like ejects herself off the side. Oh, she misses. Oh, it hits with her back legs. Yeah, but why? I mean, she doesn't know how to run on a horse? Here it is. Oh, God. What else is on here? Laura crying Facebook?
There's so many things I can't share. I've got people from every aspect of life. Are you listening, Jane Doe? From every aspect of life. Coming out of the woodworks. Yapping about you. Those aren't threats. That's called the truth is rising to the surface. Economics. You learned that there is always a price for everything.
Dave mentioned.
Would I stop talking for $10,000? No. Would I stop talking for $1 million? Yeah. I would take
This is gonna fucking piss
$1
me
million.
off. Gregory Archibald Gillespie, knock this shit off right now.
Shut up. And I would say, all right, somebody else, you're up next.
A content creator's comments about me all in one day. Oh, she would hate me. She would hate me.
Next, I'm done. Now, do I think she's going to offer me money? No, I don't.
God bless it. This is going to irritate me. All right. And then Laura Owens' horse. 5 seconds. Fake pregnancy belly. We love that. We love to see it. I want to watch it again. I want to watch it again. I know. Gregory, this is really pissing me off. Of the laptop playing a video. No, that's her.
I don't think she will. Say I'm harassing
Laura
you.
Owens,
If you
content
do all of
creator.
these things, I might go away. The next person's going to pop up, whether they're in Australia or Arizona or anywhere.
Who knew it'd be me?
It's not going away. You need to go away. It's too bad that we have to use Clayton Echard's name here to drive traffic to it.
Okay, great. All right.
But at this point,
let's go to her
it's like,
new website. And we'll just
what can you do?
We'll read around lauraowens.com. Wait, why is this archived? We knew it was you the whole time. Okay, so what is this? So let's start at the beginning. Doesn't she still have it up? Note all links were taken directly from Laura Owens' now deleted Medium essay 915, My New Reality, How Pregnancy, the Bachelor, and Miscarriage, an Online Cult, and Autism Shaped This Judgment. All right, we did that. homeforjusticeforlaura.com. It's time to hear the other side. All right, I'm just going to go to, I don't want to go to this one. I want to go to the other one, like the real one. Justice for Laura Owens. I know she was having a benefit concert. No, it didn't come down. It's still here. So let's see what she's got here. Justice. Stop pressing buttons. Okay, let's go. Justice for Laura Owens.com.
The email. What? The email.
It's time to hear the other side. Oh, hell yeah.
What do we need here? She can have him. I don't care.
When police treat a paternity case like a terror threat, Laura Owens and her family. Laura, Ron, Jan. Why the fuck is Sarah all the way over here? At dawn, on January 29th, 2025, a SWAT team executed a raid on the Scottsdale property where Laura Owens lived with her parents. Lives. 16 officers participated in the operation. They arrived just before sunrise. The target was not a fugitive. There were no allegations of weapons, explosives, or violence. No threats had been made. No one inside the home had a criminal record. Not yet, at least. Owen's parents, who also lived on the property, included her 80-year-old father, Ron Owens, who has publicly lived with Parkinson's disease for more than 2 decades, and her 69-year-old mother. And yet, the response was indistinguishable from what police departments reserve for their most dangerous cases. That fact matters not because of who Laura Owens is, but because of what SWAT units are for and what they are not.
Italian pot roast. We're talking about pot roast now? Ugh.
Understanding the role of SWAT for all of you pores. Ugh. Less than a year earlier, on May 9th of 2024, the Scottsdale Police Department publicly described the purpose of its Special Weapons and Tactics Unit in a Facebook post. The department wrote, "Actually, against the worst and most violent offenders, our SWAT team serves search warrants to arrest and capture dangerous and armed suspects. They respond to hostage calls and barricaded suspects, and overwhelmingly make the arrest or solve the crisis without a single bullet fired." Which is also what they did here. Because not a bullet was fired, so. They do constantly train for the worst case scenario, because that's typically when our community needs them most. This is not ambiguous language. It is an explicit statement of scope. SWAT exists by the department's own definition for dangerous and armed suspects, hostage situations, barricaded individuals, and the worst case scenarios where lives are at immediate risk. Nothing publicly alleged about Owens, including her harshest by her harshest critics, places her in any of those categories. She was not accused of violence. She was not accused of possessing weapons. I've never even seen a gun. She was not accused of threatening anyone. She was not accused of attempting to flee. The underlying conduct involved court filings and communications arising from a paternity dispute. No reasonable reading of Scottsdale PD's own standards places that conduct anywhere near the circumstances described in its SWAT mandate.
Also, they didn't come there for you or to arrest you or to do any of that. They just came for a search warrant. So there's that. Until she wasn't. Oh my God. She's never seen a gun unless Chris is... Who's Chris? Is she for real? Oh, God.
The aftermath of the raid. What followed deepened the concern. Members of the online group of Clayton Eckert supporters known as Justice for Clayton, God, I hate them, raised money to obtain body camera footage of the raid. The footage was then circulated online, clipped, replayed, and discussed, not as evidence, but as entertainment. The raid became content, even though the public's allowed to have those things, which is why the police gave it to them when they paid for it. So, body camera footage exists for accountability, to document police conduct for courts and the public.
No. It's not just for accountability. It's also for their safety. Like when they went in there and they had body camera footage and you're like, I'm going to get bruises. I can tell you it's for their safety. So you, someone like you, can't say that they beat the shit out of you and then left.
It is not intended to be monetized, memeified, or used as proof of guilt by spectacle. Yet in this case, the tactical nature of the raid itself was treated as validation. If the response was extreme, then the target must deserve it.
You guys, what? What are we talking about? They were securing the residence so that they could get stuff for their search warrant. Why didn't anyone tell me? I sounded like a mesh. Oh my God.
while the majority of comments were from Eckerd's supporters who loved the footage. Some public reaction reflected that dissonance. Online observers seeing the footage and descriptions compared the operation to counter-terrorism raids. One comment read, "They're acting like she's an intentional terrorist. It reminds me of when they found Bin Laden." Oh my fucking God. It reminds me of when they found Bin Laden. Another said, "This looks like they're searching for a terrorist."
To be fair, she does terrorize men. Question mark. Oh my God.
The implications of overreach. It is possible to believe every allegation against Owens and still recognize that this response was unjustified.
You know what? Laura, I'm not trying to give you any advice here, but you do realize, like, had you not acted like a complete asshole on those videos, nobody would have been able to make the content that they do. So, Laura talking in third person is so funny.
SWAT raids are not meant to resolve disputes about credibility.
You're right, which is why they were there on a search warrant.
They are not meant to dramatize investigations. They are not meant to satisfy an audience or confirm a narrative. They are meant to stop imminent danger. When the most extreme tool, that would be me, when the most extreme tool of the law of law enforcement is used where no such danger exists, and then celebrated, monetized, and consumed as entertainment, the issue is no longer one defendant. It is whether the state still remembers why those tools exist at all. Because when a state deploys its most extreme law enforcement tools against a non-violent defendant with no criminal history in a case rooted in family court filings, while thousands of similarly situated cases are handled civilly and quietly, the issue is no longer judgment or caution. It is selective prosecution, made visible not by what the law required, but by who the defendant filed the complaint against. How loudly the internet demanded punishment, and how willing the system was to oblige. 4,448 views. 4,048 views, 5 hearts. Should I heart it?
Here's the thing. The thing that pisses me off the most about this is she's like, this was unjust. Laura, have you ever seen how police departments like this treat black people? Have you ever just gone through that body cam footage? Black people who are compliant? You literally double finger birded Maricopa County, told them to fuck off and fought against them. And you want to call this unjust? Good Lord. Right. Nobody got their arms twisted. Right. Guns were not drawn. Ugh. Spelling her name on the stand. Oh my God. She flipped off. Right. Right. Oh, this is insane. Ugh. The entitlement is top tier. Right, double middle in their face. She was like this in their faces. And you're going to be like, this was unjust. They came in to search for a search warrant. So we read the contractor judgments. All right, what else do we got? Let's go back. Let's just kind of do these in order. All right, read that one. Good Lord. Yeah, it's amazing to me. It's amazing. It's amazing. It's irritating.
A case that reached the internet before the court. Here's me and my uber famous dad. So, if you were wondering. There are moments in criminal cases when the central concern is no longer the allegation itself, but the integrity of the process by which the prosecution is unfolding. And I was totally down with the justice system until it started to turn around on me. Now I fucking hate it. Being persecuted. State of Arizona versus Laura Michelle Owens has reached that point. A case that reached the internet. Because I put it there. The issue presented here is one of procedure and constitutional fairness. Whether a criminal prosecution can be said to comply with due process when a sealed superseding indictment enters public circulation through online channels before the court authorizes its release. The concerns did not arise suddenly. They accumulated. Indictment posted by a JFC-aligned account in early November 2025 bearing no file stamp or case number. On November 11th of 2025, Justice for Clayton aligned content creator Omar Serrato live streamed himself scrolling through and reading from what he presented as a superseding indictment against Laura Owens. He displayed the document itself and treated it as the operative charging instrument. The document shown during that live stream was not file stamped and continues to appear on the Victims of Laura Owens website. It did not contain a true bill certification from the grand jury foreperson. Most critically, it did not contain a criminal case number. Instead, it bore only a grand jury identifier. Hi, Vanessa. That distinction is significant. Public access to criminal filings depend on the existence of a criminal case number. Without one, there is no public docket to search, no e-access entry to retrieve, and no lawful mechanism by which a member of the public can obtain or verify the document through court records. For all you noobs who don't understand how the justice system works, I'll just have to tell you because I've been abusing it for years. At the time of November 11th live stream, the superseding indictment was not accessible on the Maricopa County Superior Court docket, sealed or otherwise, because it had not yet been unsealed and had not been attached to a publicly accessible criminal case. There was no docket container through which it could be obtained. Even the defendant would not have been able to locate it independently through court records at that stage. According to a user posting on the Justice for Clayton subreddit, the superseding indictment was not unsealed until December 2nd of 2025, more than 3 weeks later. That same day, online discussion reflected that the indictment had finally become available through lawful court channels, underscoring how closely this case is being monitored once the court opens the record. The sequence matters. Before a criminal case number is assigned and a sealing order is lifted, an indictment exists only within non-public systems. Grand jury materials, prosecutorial charging files, law enforcement coordination channels, or clerk intake queues. By design, there is no lawful public pathway to obtain such a document at that stage. This structure exists to protect due process by ensuring that charges are introduced through the court in a neutral manner, and at a time chosen by the judiciary rather than by private actors.
Oh my god. I go to places to get the documents that I gave to my free use AI account. What? Oh my god. This is making my belly hurt.
Yet here the indictment entered public discourse before any of those safeguards were in place. This does not require an assumption of intentional misconduct. There are several plausible explanations for how a document could escape custody without deliberate wrongdoing.
Oh yeah, this is her website.
We don't know who made it though, it's a volunteer. Large prosecutors' offices involve multiple layers of access. Attorneys, investigators, law enforcement partners, analysts, and support staff. Drafts and finalized charging instruments may circulate internally for review, coordination, or logistical preparation of failure of protocol, an informal share or misunderstanding of sealing. Obligations can be enough to allow a document to leave controlled channels. But the source of the disclosure, while important, is not the threshold constitutional issue. The issue is custody and control.
I blame Greg. Me too. Let's see. Is it just my chat? I think so. I don't see it like that. So, right. I don't know. I don't know what's happening here. Funny how all of their supporters want to remain anonymous. Right, nobody ever wants to come out. Clan B, drinking my cold brew and oat milk. Oh, oat milk is so good. Which is it? Well, let me read it to you.
Maybe you'll understand. You noob who does not know about the legal process. Because I know everything, because I'm in the courthouse every day. Due process requires that the court, not outside actors, control when and how criminal charges become public. When a sealed indictment reaches the public first through advocacy media rather than through a court order, the defendant is denied the protection of a neutral starting point. The case begins not in the courtroom, but in a public commentary. Before the defense can respond through lawful channels and before the court has exercised its gatekeeping role. that harm is not cured simply because the indictment is later unsealed. Due process violations turn on timing, notice, and fairness, not on whether the same information eventually became public. Once the sequence is broken, the prejudice cannot be undone retroactively. Three days after the November 11th live stream, on November 14th, Maricopa County Attorney Rachel Mitchell held a press conference in which she discussed how unusually fucking popular I am. Click, click, pictures. But how unusually popular this case has become online. She described checking her social media notifications, joked about the volume of attention, and acknowledged almost jokingly that this investigation generates more online engagement than anything else she sees. I should be getting those likes. I should be getting those subscribes. I am up-and-coming podcaster Laura Owens. In the context of an active criminal prosecution, however, they raised a more serious concern, a case unfolding with open awareness of and apparent comfort with an online audience. My online audience. Prosecutors are not meant to be entertained by public fervor. They are expected to be insulated from it when public fascination becomes part of the atmosphere rather than a risk to be managed. The boundaries that protect due process begin to erode. And if there is anyone who knows anything about boundaries, it's me. Marsha. Oh, God. Taken together, the sequence raises a serious constitutional question of whether the state can credibly maintain that this prosecution unfolded within the procedural guardrails required by due process. When a sealed superseding indictment was publicly displayed before it was lawfully accessible through court.
You know, she could get to her point much faster if she didn't repeat herself, honestly.
This is not an argument about guilt or innocence. It is an argument about whether the defendant was afforded the basic due process protections guaranteed at the outset of a criminal case. Fair notice, court-controlled disclosure, and a proceeding free from premature public adjudication. Because sometimes you dribble before your felonies, and sometimes you dribble after. Accordingly, the state must account for how the superseding indictment, lacking a file stamp, lacking a criminal case number, and lacking judicial authorization for release, was obtained by third parties and publicly read on November 11th, and why that same version continues to appear on the Victims of Laura Owens website. Let's type it up. At minimum, the state should be required to answer the following. How did a non-party obtain a copy of the superseding indictment before it was unsealed by a court order? From which custodial channel did the document originate, including prosecutorial files, law enforcement coordination materials, clerk intake processes, or grand jury related records? Who had authorized access to the indictment during the sealed period and what safeguards were in place to prevent dissemination? Was any version of the indictment shared outside of the county attorney's office prior to unsealing, and if so, with whom and for what purpose? Why did the version publicly circulated lack a file stamp, true bill certification, and criminal case number, confirming it was not a publicly released court filing?
Do you think maybe they could have edited it out? So, Lord. What is that? She has maladaptive daydreaming? Ugh. Right, then ask them. Why didn't you ask them? Ugh. Haven't even updated their website for a long time. Without any of that? I don't know. This is from her website. Maladaptive daydreaming. Oh, God.
If the state can provide a clear, credible explanation, like they asked me to provide a clear, credible evidence about my pregnancy, but we're not on that right now, are we? Yeah. If the state can provide a clear, credible explanation establishing that custody was maintained and that due process was preserved despite the sequence, the court may then assess whether the violation is curable, like my case of the perjurers. But if the state cannot answer these questions, or if the answers confirm that a sealed charging instrument left in non-public custody and entered the hands of an openly hostile advocacy group called Justice for Clayton, goddamn those motherfuckers, during a protected period, then the constitutional harm is complete. In that circumstance, dismissal is not discretionary. A criminal prosecution cannot proceed where its initiating document entered public disclosure through partisan channels before judicial release and outside court control. Allowing the case to continue would not remedy the violation. It would ratify it. Due process does not require proof of intent, nor does it require the defendant to identify the source of the breach. The obligation to safeguard sealed charging instruments rests entirely with the state, because I don't want to do any of the work, ever. When that obligation fails, and when that failure cannot be explained or cured, dismissal is the only remedy that preserves the court's authority and the integrity of the criminal process. For Hertz.
People be leaving hearts on this. Who? Who be leaving hearts? God, this is bullshit. Oh, my brain is starting to smooth over. Somebody yesterday was talking about ambition, and then I was talking about my husband and like myself and people that I know, and somebody was like, you need ambition to be a garbage man, and I was like, fuck you. Why did property taxes go up? Oh God. It's not a due process violation. Oh my God. We've struggled to find one supporter. Even Sarah Boone, Jodi Arias, and Casey Anthony have passionate defenders, but Laura has none. And she doesn't understand why. Right. Yeah. Oh, no, they did get banned. We got rid of them. I mean, her supporters think this would achieve anything. Like JFC would read it and go, damn, she's right. Oh, God. Ugh. Yep. Question mark. Getting tired of this, B. Just now? 4 likes is actually worse than 0 likes. Oh, God. I don't know what she's doing. But, like, why write it on your blog? Like, why not bring that up? Why not, like, you know. I am exhausted. Read more. Sure. I'd love to. We went over this one, how justice for Clayton turned a contractor with judgments and a revoked thing against her. We've read this one. We read this one. The Nation. Wait, is this go in order? December 25. 13. She uploaded these all at the same time. 13. All right, let's start at the bottom. Everything I do it for you. All right. This is called The Missing Element. Why Intent Collapses the Case against Laura Owens. Did we check the source code? Give me the source code. Oh my God. What do I need? I need something. I need like just, I feel, enterprise and inspiration. Yeah, I feel like that's good. We want like happy music because she's going to feel this, right? She's so good at this. No, yeah, I need, hold on, inspirational. Laura's starting to feel herself. She's like, we got this. Let's see.
Here we go. The Missing Element. Why Intent Collapses the Case against Laura Owens. Criminal prosecutions are often framed as disputes over facts, but beneath the surface, every felony case turns on a more exacting question. Whether the defendant possessed criminal intent at the moment the alleged conduct occurred. Not confusion, not fear, not emotional distress. Intent! Mens rea. Requires knowledge and purpose of the law, recognizes as culpable. That requirement is not a technicality. It is a constitutional safeguard designed to prevent the criminal law from punishing people for conduct that was not clearly understood at the time to be criminal. Measured against that standard, the prosecution of Laura Owens encounters a structural problem that cannot be cured by narrative force or public disapproval. The state has charged conduct that unfolded in a legal environment where criminal liability had never been contemplated. We gotta start somewhere. And it was done so without a viable theory of intent. Even if every disputed factual inference were resolved against Owens, the mental state required by law remains absent. My mental state remains absent.
Oh my God. Wow, I am 4 hours behind. Is anyone else melting? Oh my God.
Criminal intent requires fair notice. Mens rea presupposes foreseeability. A person cannot intend to commit a felony unless the law has given fair notice that the conduct at issue is criminal. For more than half a century, paternity petitions filed during pregnancy, even those later withdrawn, dismissed, or proven mistaken, have been treated uniformly as civil matters in the United States of America.
Oh great, vomiting face emoji. Another Jack Fox video. Fake news. You can't interpret me. I'm autistic. Mommy says so.
You're artistic.
Everybody knows you're artistic. We stand Jack Fox here. Everybody go. Watch Jack Fox. Mens rea. The fair notice is called the law. Right. This is too happy. No, I need here's an inspirational score. Yes.
Courts have sanctioned parties, awarded fees, criticized credibility, and dismissed cases. They have not referred women for prosecution, let alone charged them with serious felonies. That historical practice matters. It defines the legal environment in which conduct occurs. Where prosecution, also.
You brought forth a frivolous case in court. You can't do that. That's legitimately against the law. So there's that.
Where prosecution has never been contemplated, intent cannot be inferred after the fact. A defendant cannot form the intent to commit a crime that the legal system itself has never recognized. If Arizona now wishes to criminalize certain uses of the family court system, like telling someone that you have twins but you don't, and you're dragging them through the court system so that you could drain their bank account, ruin their lives, and maybe send them into bankruptcy and destroy their reputations, it may seek legislative authorization going forward. What it cannot do, consistent with due process, is retroactively assign criminal intent to conduct that occurred in a framework where criminal exposure was unimaginable.
I feel like she imagines herself standing on a box in front of people in New York City, giving a big talk. I don't know, she's some sort of this is her doing her TED talk. So yeah, I don't know. I would be hoping for jury duty. You have no idea.
Mental state is not abstract. It's contextual. Guys, we have a
repeat from yesterday. It is not, mental state is not abstract. It's contextual. It's contextual, like numbers. The numbers are contextual. Why didn't you pay your mortgage? You have to know the context. Okay.
Intent does not exist in a vacuum. Even though I don't know what a vacuum is. What am I, poor? What the fuck? Who has a vacuum? Cleaning? Yuck. That's for you peasants. Courts routinely consider whether a defendant's mental and cognitive profile acts how actions are perceived, processed, and understood. Owens has publicly disclosed that she is artistic, agnostic, autistic, and has been diagnosed with panic disorder, anxiety, depression, post-traumatic stress disorder, and traumatic brain injury. Just in case you were wondering. But not limited to. These conditions are not invoked to excuse wrongdoing. They are relevant because criminal intent requires conscious, knowing deception, not misunderstanding, not miscommunication, not emotional dysregulation or distorted threat perception. Shut the
Fuck up. Shut up. Shut up. Oh my God. Again, Laura, coming out and saying you're autistic so you just like can't be capable of these things. That's not how this works. You can be autistic and also capable of criminal behavior. Two things can happen at the same time. You being like, I'm autistic, it excuses me. No, it does not. No, it does not. God, if you put this much job into work. Oh, here she goes. Here she goes. No, girl, because they don't have it. Not unless she forged it. They don't have it. Here we go. She's going to explain this. Oh, explain this to me. Explain this to me, Laura.
Hold on.
She would be very sad about this because remember how she talked about having a child with disabilities?
Autism spectrum conditions, in particular, are well documented to affect social communication, which is why I wanted to become a podcaster, right? Because I struggle with that. Interpretation of interpersonal cues. I can't tell when somebody is rejecting me. I don't know when to give up. I don't know when to take no for an answer, things like that, right? And responses under stress. Sometimes autistic people, when they are under stress, they go to the courthouse and they file frivolous lawsuits and frivolous paternity establishment cases and abortion coercion cases. And they drag people through the legal system for years to ruin their lives. Sometimes that's just how autistic people handle stress, tomato, tomato. Sometimes people have meltdowns and cover their ears because they're overstimulated, and sometimes you just file 175 motions in a courtroom. Panic disorder and PTSD further complicate perception during emotional charged events. None of these conditions negate responsibility, but they do bear directly on whether conduct reflects calculated criminal purpose or maladaptive response to crisis. Crisis that I caused and should definitely not be punished for.
Ugh. Boo his tomato, tomato. Let's see. I have no style, so I can't talk shit about the way people dress. I have none.
Criminal law distinguishes sharply between deliberate fraud and conduct driven by confusion, fear, or impaired judgment, where mental health conditions plausibly affect how someone understands and reacts to a situation. The inference of intent must be supported by evidence, not assumed. And here, that evidence is absent. All the evidence is absent. All the evidence that I ever brought you is absent. I don't have anything to substantiate these claims. The absence of motive is the absence of intent. I'm sorry?
The absence of motive is absence of intent? Is that... Right. Thank you, Minnie T. Exactly.
Because intent is rarely proven. She's on a roll. After hours, you're a lawyer, you should know this. The absence of motive is the absence of intent. Let her cook. Because intent is rarely proven directly, courts look to motive. You see, fraud schemes are driven by gain. Extortion is driven by leverage. Perjury is driven by the desire to avoid consequences.
Tell me more. Tell me more.
In the Eckerd matter, Owen stood nothing to gain unless Eckerd was biologically determined to be the father. The fact she could not control and that testing alone could establish. If he was not the father, she would receive nothing. Filing a paternity petition does not generate money, advantage, or leverage. It triggers a binary process that ends in confirmation or dismissal. Or option C, 14 felony charges. In the earlier Gillespie matter, the civil litigation likewise did not present any meaningful financial incentive consistent with a criminal scheme. At one point, Owens proposed that any monetary remedy be directed to a woman's charity rather than herself. That woman's charity was probably in the name of Dan Blowens. Whatever one thinks of that proposal, it does not resemble the architecture of intentional fraud. When conduct produces no discernible benefit, motive collapses. And when motive collapses, intent cannot be fraud.
My brain hurts. It hurts. Right. Here's the thing. Your goal, okay, fraud schemes are driven by gain. The gain is to get these men to date you. Or the gain is to ruin their lives so that way you can justify hurting them because they hurt you or what you perceive that as. Extortion is driven by leverage. The leverage is having the DVROs against them so that A, they have to be connected to you, or B, you have the leverage to ruin their lives. Perjury, which you have fucking 6 counts of, is the desire to avoid consequences. So tell me, why did you lie under oath? The title, When Two Things Can Be True. Oh, God. I think my retinas need to be changed. She did all these things, but no one knows why. God.
When two things can be true and still not a crime. When the state's perjury allegations sharpen the problem rather than resolving it, one such count related to Eckerd focuses on statements concerning sexual exclusivity during a window in which conception could have occurred. For that statement to be material and essentially an essential element of perjury, the possibility of pregnancy must be taken seriously. Where are we here? Let's make this huge. Maybe not that huge. All right, that's good. If pregnancy was never possible, exclusivity is legally irrelevant. If pregnancy was possible, then the case necessarily involves early gestation, an arena defined by medical uncertainty rather than certainty.
What the fuck? What is this saying? For that statement to be material, an essential element of perjury, the possibility of pregnancy must be taken seriously. If pregnancy was never possible, exclusivity is legally irrelevant. If pregnancy was possible, then the case necessarily involves early gestation, an arena defined by medical uncertainty rather than certainty. I'm so confused. So, okay. Perjury. In order for her to lie, she's saying in order for her to lie under oath, to be charged with perjury, they have to believe that she was pregnant by Clayton? I'm so confused. Okay, I should copy this and put it into ChatGPT and be like, explain this to me like I'm 5. I don't understand this.
Either way, the elements fail. A statement that cannot influence a legal outcome is not perjury.
A legal outcome, a statement that cannot influence a legal outcome is not perjury. But you did influence a legal outcome. Guys, my brain hurts. Leaning back with a big smile on her face going, that told. Got him. Got him. I don't.
A statement made amid unresolved biological conditions cannot be shown to be knowingly false at the moment it was made.
Okay, Bruce. All right, let's logic for a second, okay? We're going to play Bruce's game for a second, okay? Explain this to me. Come on, Bruce. Logic master. Let's go. Let's go. Go ahead and explain all this to me. What the fuck is she saying? Oh my God. Since I lost that case, it isn't perjury. No, Bruce wants the logic. Go ahead. If A, then B. Stop it. A is true, therefore B is true. Somebody block Bruce. Just a whole bunch of peas. Do it, do it. Yeah. You can lie under oath as long as it doesn't affect the outcome. You can just like perjure all over the place. You know? I know I don't have any aneurysms lurking in my head. Is that we need to believe she was pregnant to be able to prosecute her for perjury. But the perjury is that you said that you were pregnant and you weren't. YouTube is broken.
The prosecution cannot simultaneously deny pregnancy and rely on the mechanics of conception without defeating its own theory of intent.
You could not prove you were pregnant. Ironic, dramatic. Ugh, thank you, Kayla. I don't... False. Amen. Ramen. It's happening. You need to prove she thought that she was pregnant. But it comes out of the basis of thoughts when she has physical items. When she talks about going to doctors, she's attempting to say she had nothing to gain unless she was pregnant. Therefore, if she wasn't pregnant or lying, there was no harm, no foul. Except when she took them to court and drained all their fucking bank accounts. It was crazy. Context. Always context. I'm innocent, there's reasons, but they don't really matter because the universe is infinite and therefore nothing is impossible and everything is contextual. So back to the apps I go. Game, set, match. Not a thought to be had in little baby no thoughts. You know how they're like, you should do like Sudoku and stuff to make you smarter? I think us doing this makes us smarter. Take a chance on saying yes and end up having to spend a weekend with them. That. No, you hang up. No, you hang up. You hang up. What is pregnancy? A state of mind, a state of being. I feel like she thinks she's doing the equivalent of quantum physics with words. Oh my God. Good Lord.
No intent exists where the defendant tried to disappear, not benefit. What the fuck is this? If Owens were engineering a calculated deception, one would expect behavior consistent with self-promotion, attention-seeking, strategic leaks, public positioning. Guys? Guys?
Did she not do this? Didn't she literally do this? She did it first. Oh my God. No, I know what it was. I just want to know why it was a remix. Self-promotion leaks going to the sun? Right. Public positioning? Seeking attention by arguing with people on Reddit? Self-promotion? Tell us more about your podcast, Laura. Pay no attention to the media blog behind the curtain.
Instead, once the matter became public, she retreated. She approached the press anonymously. Begged and pleaded, girl, that the journalist not publish her name. She stopped producing new podcast episodes and shut down her public social media accounts, except for my LinkedIn's where it told everybody I was the CEO of 4 different companies. That is not the profile of a fraudster. It is the profile of a person who expected nothing from the process except privacy. Except for the fact that I wanted to be a public figure, you know what I mean? The law presumes intent from actions. And every action here points not to scheming, but to fear, confusion, and the instinct to withdraw. Even though I kept going and never actually withdraw. None of those mental states satisfy the intent element of any felony.
So if I commit a murder and then I run from the crime scene, that's not actually a felony? Is that, I just gotta go, right? If I withdraw, if I withdraw, then I'm cool, right? Right. It was not intentional. I'm remembering my old room. Oh, God. I thought CEOs got paid. Shut up, LJ God. No, they don't. Not in this world. Ugh. So if I punch you in the face and leave, I'm cool.
Without intent, the prosecution has, how do they call it? Je ne sais quoi? Narrative, not law. A prosecution without intent is not a prosecution.
Hey, funny story. They actually don't have to prove, like, motive. They just have to prove that you did what you're being charged with, which is lying under oath, stealing the identity of another, fraudulent schemes and artifices that you lied to gain something. So, you know, there's that, right? Right? Is there that? Buzzer says, you lied. I need the buzzer. I need a... Motive is not an element of crime. Right. Just the fact that you fucking did it. I don't have to have motive. They just need to know that I committed the crime.
And stories, even though I am a master storyteller myself, do not convict people in constitutional systems. Statutes do. Fraud requires a deliberate plan to obtain a benefit. Perjury requires knowledge of falsity. And we all know collectively that I have no knowledge of anything. Kayla, thank you for those gold coins. Identity theft requires purposeful misrepresentation for Shut the fuck up.
Tell me, Laura, why did you steal another woman's ultrasound? Why did you email your boyfriends that you were, thank you for the gift, Karen, that you were doctors when you weren't?
Extortion requires an attempt to coerce payment or advantage. And the advantage was that I would have an abortion if you would date me. And none of you would date me if I had the abortion.
I was just thinking about that, Rachel. I'm like, could you imagine the prosecutors reading this and being like, how is she going to explain to me my job? Hey, you guys, I just want to let you guys know that I'm taking a course in investigation, procedures and processes. And I passed a course with an 84% of criminology and criminal justice fundamentals. I'm going to start writing blogs about how our criminal justice system works. So all of you people who went to fucking four-year colleges to be lawyers can fuck off. Oh, God. I know. Who is she writing this to? Who does she think reads this? Because it's me, back to music.
Talking like this. Was this what you envisioned, Laura? Was it this?
Idiot.
None of these elements survive sustained scrutiny here. Not because the facts are undisputed. Did you just say this?
None of these elements survive sustained scrutiny here, not because the facts are undisputed.
Does this make you happy? Because I don't feel very compelled, Jay.
Not because the facts are...
I'm not undisputing the facts that I have perjured, that I have tried to extort, that I have fraudulent schemes and artifices. But because of the mental state required by law cannot be established in a context where the conduct was lawful. The outcomes uncertain. The incentives absent. And the precedent non-existent. Uncle Joe Cotchett was right when he said this would be a landmark case. Absent intent, what remains is a story, my story. Laura Michelle Owens, hi. 5'5", 85 pounds, if you were wondering, love long walks on the beach. And stories, however compelling, are not crimes. Except for these stories, which are crimes. So there's that. Huh.
Good, I'm done. Okay, what else do we got? Oh, hell yeah.
Opinion. Fucking idiot.
I have to put opinion on this.
Opinion. Rachel Mitchell turned one disabled woman's love life into a 14-count felony spectacle. I fucking can't with this bullshit. When the story first hit Arizona news, it sounded like something dreamed up in a TV writer's room, perhaps on ABC's The Bachelor. Have you heard of it? The show about The Bachelor where a guy gives out roses to women. Sometimes they do a bachelorette, sometimes they do old people, you know. People give out roses. Clang! A Phoenix woman, Laura Owens, supposedly fakes a pregnancy with former Bachelor lead. Did you guys know he was on The Bachelor? Did you know? It's The Bachelor. Clayton Echard files a paternity case, loses, and then somehow, some fucking how, ends up criminally indicted on 7 felony counts in May of 2025. The headline said an online group called Justice for Clayton, those dirty motherfuckers, helped expose her. And Maricopa County Attorney Rachel Mitchell swooped in to finish the job. The message was clear. You don't pull felony charges out of a family court mess unless it's really, really bad. And I didn't think it was that bad. I just lied about being pregnant to drain this man of $150,000. In a world where paternity cases usually end with DNA results, you're not the father, and blocked numbers, the public was told to take the leap. She must be guilty, trust us! I more or less did. Until Mitchell went back for seconds. Last week, she announced a superseding indictment adding 7 more felonies. This time wrapped around an early relationship where I did this again with a man named Greg Archibald Gillespie, whom Owens had sued in 2021 for abortion coercion. Abortion coercion! Overnight, Owens stopped being just the woman who supposedly lied to a famous TV personality, The Bachelor, if you guys didn't know. He was The Bachelor. And became, in Mitchell's telling, the architect of 2 separate fraud schemes. She should know me better than that. I never wanted to be an architect. I wanted to be a podcaster. Years apart, now staring at 14 felonies over 2 short, failed relationships because I can't keep one to save my life. At that point, the story stopped sounding tough and started sounding strange. If this was really just about protecting the public, why did it read more like a Bachelor season arc than a charging decision? So I did what the press largely hasn't bothered to do. I went past the JFC threads and slick breakdowns, pulled the dockets, read the civil and family court filings in full. Oh bitch, I've read them in full. And walked through both indictments, line by line. I went looking for the massive hidden fraud that would justify turning a family court disaster into a 14-count epic. I didn't find it. What I found instead was this. In both the Echard and Gillespie cases, the record includes early clinic-run HCG pregnancy tests that came back positive. Tests from licensed medical providers that neither man nor his lawyers has ever claimed were forged. Echard even admitted to inviting me over to his apartment. You remember that, Clayton? Under false pretenses to take a pregnancy test, which he purchased, but it was positive, right? It was positive. And long before Mitchell branded Owens a fraud, Arizona judges had also granted her a 2-year order of protection against Eckert, which he contested twice and lost, expiring only last month. And 3 separate orders of protection against Gillespie, 1 still active. None of that shows up in Mitchell's press releases or in the national coverage that treated those releases as gospel. Yet it is Owens. Go to the bathroom, Malin. Yet it is Owens, a 35-year-old autistic woman. A 35-year-old artistic woman who reportedly weighs in the 80s, even though I said that's a goal on one of my other blogs, with no prior criminal record, who is now being treated as if she were running a high-end criminal racket. Please. I have 2 jumping beans in my brain and they're jumping away from each other. I could never pull that off. Across the 2 indictments, she faces 2 charges in the same felony class as manslaughter, plus 5 perjury counts and a stack, girl, a stack, like my laundry bags in the casita, of additional felonies. On paper, if a judge ever ran the maximums back to back, she could be looking at more than 60 years. Effectively, life in prison. Sad. Sad. It's almost like our consequences of actions over how she handled the worst months of her love life. 3 different times. Neither man says she wanted his money. Neither claims physical injury. With Eckert, she asked for a parenting plan, not a payout. With Gillespie, she once proposed that any judgment in the civil case go to charity, not herself. In their own telling, she was chasing connection, not cash.
Oh, is it possible that connection was the gain? You idiot. Oh, yeah, that's right. She was left for dead. That wasn't one of the worst moments of her life? Right. Right. Connection. And what would you get right? I managed not to... yeah. Yeah, sometimes, yeah. This has to be the last one. I think I'm going to have to go take a nap.
You can believe she was never pregnant. You can believe she was. I hope you do, huh? Or you can sit uneasily in the middle. And the question still doesn't go away. How did a woman, the state, itself effectively paints as desperate for relationships, wind up charged like someone who killed 2 people?
Where are the twins, Laura? Where are the twins? I would like to know where those 2 people are. Am I pregnant?
And once you ask that, the next question is even uglier. If this were the exact same mess between 2 warehouse co-workers in West Phoenix, oh, so poor. No bachelor lead, you know what I'm saying? No built-in fan base. No Reddit vigilantes. Is there any chance Rachel Mitchell would have sent a tactical team through a front door, assigned a special crimes prosecutor, and stretched 2 chaotic relationships into a 14-count felony saga in a county with more than 13,000 violent crimes a year? Most of them unsolved? God, so not only is Maricopa County poor, you're also lazy. Ugh.
Yeah, actually, I would still watch this. Hi, Dana. How are you? Naps for Bacon Bearzz. That's me. Oh, God. Or I could just get a cup of coffee. Maybe I'll do that. Grew me as a person and brought me closer to people. Suck on that! That's right. Girl, why didn't you call me? Is your mom listening to this right now?
Hi.
You should call me. Good Lord.
Or is this what happens when a reality TV mob picks its villain? A celebrity brings his own cheering section, and an elected prosecutor decides that in a place drowning in actual violence, the safest legacy play is turning one disabled woman's love life into a felony spectacle and treating her like she's already been convicted.
Actually, you're just treating how people get when they get charged with stuff. So there's that. Where they... I'm racking up the cheese mate before I call you. Hell yeah, I'll make sure my earphones are charged. What if we kissed? Okay, good. Ugh. We would call you because we... Your best friends. Oh, God. Right. She's like, just because these other people are charged with crimes, it means I shouldn't be charged with crimes. Duh.
The Eckerd case. The Eckerd chapter began the way a lot of bad stories do. A one-night hookup in August of 2023, followed by panic and lawyers. Hi, D-Buggy. How are you? In the paternity record, this is not a she just made it up out of nowhere scenario.
It's not? It's not? I just love it so. We're your friends now. Laura Owens, is that you?
Owens produced early positive urine and blood HCG tests from actual clinics. Media coverage summarizing the record acknowledges those tests. Nobody, not Eckerd, not the state, has claimed that the labs themselves were forged or that the clinic staff were in on some conspiracy. Owens has said she also took a positive home pregnancy test in front of Eckerd. He has acknowledged it in interviews that she took a test in his presence, even as he disputes what it meant. Her paternity petition asked for a parenting plan and shared responsibility, not a giant damages award or a lifetime payout. All I wanted was for him to talk to me. Months later, she told the court she had miscarried. How many months later?
9? How many months later? It was like 7 months later.
And moved to dismiss her own paternity case. Both parties were still representing themselves. And at that fork in the road, a judge could have simply granted the dismissal, closed the file, and left 2 adults to crawl out of a disaster. But instead, fucking Eckerd hired counsel and pushed to keep this litigation alive. Like my twins that I can't find. So, there's that.
Their date was in May. Their first date was their hookup was May 20th. A one-night hookup in August of 2023. You're right. This is wrong. This is wrong.
For a declaration that he was not the father, a formal teardown of Owens's credibility and his fees. Judge Julie Matta obliged. Not that it's his right to have a counterclaim or anything. Whatever. It's fine. In June 2024, she issued a scathing ruling, finding Owens's claims not grounded in fact. A lot like this blog. Ordering her to pay roughly $149,000 in Eckerd's fees, and referring her to the Maricopa County Attorney's Office for possible perjury and evidence tampering over an ultrasound image. God! And video she'd shared privately, not as court exhibits. I was just trying to extort him, okay? God. That referral plus a growing online campaign is what turned a collapsed paternity case into a criminal file. Not the fact that I did criminal crime. That didn't do it. From paternity case to fandom campaign. Eckerd did not walk into this as a universally beloved figure. His season of The Bachelor, everyone. The Bachelor, Clang, was widely criticized. I would know, I watched it. One recap famously asked whether he was the biggest fuckboy in Bachelor history. His public brand was guy who humiliated women on television, not model citizen.
Hey, guess what? Did you know that you could still be a fuckboy and not, like, commit crimes? And, like, whatever? So what if he's not liked? Also, I don't understand why I didn't watch his season. I don't watch The Bachelor. I don't understand why he was not liked, because he was open and honest with women about sleeping with them. What don't we like about that? I'm confused. Right. Comments about a show she's never watched.
Owens' paternity petition handed him something much better. A redemption role that I didn't fucking see coming, and I regret now. In his retelling on podcasts and reality spin-offs, he became the nearly ruined man targeted by a woman who would supposedly say anything. A storyline he has repeated so often that the litigation now functions as season 2 of his media life rather than a one-off court case.
Hey, listen, just take a good look at New York, right? Tiffany Pollard or Natalie Nunn. They're villains, still doing shit with their lives. This could be you, Laura. I believe in you. I believe in you. And yet Laura gobbled into... Like some gizzards after Sunday church. You know what I'm saying? You know what I'm saying? Oh, God. I don't know. Mackenzie Sharilla's doing all right, Jack. And she's awful.
Around that storyline, a cottage industry grew. Under the Justice for Clayton, goddammit you motherfuckers banner, accounts sprang up on X, Instagram, Reddit, and YouTube. Especially this fucking bitch named Bacon Bearzz. If you guys aren't already subscribed, please go down. Please consider doing so. We have so much fun here. Along with dedicated sites for the cause, they do not read like casual fan pages. I know, because I've read all of them. They read like an organized project to turn one woman into a permanent villain, even though they wouldn't have context and content if I didn't keep giving it to them. There's multi-page wikis cataloging the Laura Owens court cases, curated timelines of every filing, links to fundraisers for the men. Yuck. And a whole playlist of monetized commentary content breaking down her medical records, text messages, and court appearances episode by episode. I'm Ms. Wings. In the comments section, strangers who have never met Owens vote on whether a new filing will make her a monster, a predator, or a pathological liar. Her life is treated as content to be refreshed, not a reality to be lived in. The fixation hasn't stayed online. Supporters trade court dates, travel to hearings, live post from the hallway even though it's their right to do, and treat routine status conferences like fan conventions. Money is raised to buy police body cam footage and obtain records, which is also their legal right. The resulting clips are chopped into reaction videos and passed around for sport. The emotional through line is not concern about the integrity of the legal system. It is hostility towards a single woman, who in this universe has stopped being a person altogether and become a hated character they feel entitled to drag from platform to platform.
Stop doing shit then. Stop doing shit. If you stop doing shit, we stop talking about said shit. She's making it sound great. I know. God.
Eventually, the campaign stopped just talking about prosecution and started trying to engineer it. Oh, fuck. Conservative commentator Charlie Kirk hosted Eckerd, framed him as the target of a false accuser, and promised to pressure Mitchell, publicly and privately, to bring charges. JFC members circulated letter templates urging Maricopa County Attorney Rachel Mitchell to indict Owens. And just days after Judge Matta's referral, photographs circulated of Mitchell smiling beside a Justice for Clayton supporter. I stood outside for 3 hours. Nobody wanted to take photos with me. She was holding one of those letters calling for Owens' prosecution. A picture of JFC accounts themselves promoted as proof their effort was paying off.
I've never heard of this. How cool. How do I join? Come here, Becca. I have Kool-Aid for you. But we do not stop drawing stuff. Oh my god. She was big mad. No, your horse drags you. Stop breaking the law. Hi, John. Oh, God. So Rachel Mitchell listened to the people she's supposed to represent? Groundbreaking. Florals in spring. Woohoo! Oh my god.
Most prosecutors confronted with that level of organized fandom and personal animus toward a single defendant make a point of saying they don't take charging requests from online mobs. Mitchell didn't just ignore the line. She stepped over it. Then let the same ecosystem that hounded Owens for months serve as her loudest cheering section for doing her job and putting a criminal behind bars. A SWAT-style raid over pregnancy fraud.
How many times are we going to fucking repeat the same thing? I am late tired. And I'm hungry, and I'm crabby. Who's paying for this website? I do not know.
Rather than quietly assigning a line prosecutor to review transcripts and medical records, Mitchell handed the file to Edward Leiter, a senior a guy who knows what he's doing, special crimes attorney whose usual portfolio includes terrorism, gangs, and organized crime. I only do 2 of these things. I don't have a gang because I don't have any friends. Then Mitchell's office helped greenlight the pre-dawn tactical raid on the Owens family home. On January 29th, 2025. Oh wait, we need tension. I need tension. Here we go. Oh, fear and adrenaline, hell yeah. All right. On January 29th of 2025, Scottsdale Special Assignments Unit, its tactical SWAT arm, executed a pre-dawn warrant at the Owens property. According to publicly available Scottsdale PD documents, 16 officers were deployed. Inside the main house were Owens' elderly parents, including her 80-year-old father, National Radio Hall of Fame inductee, Ron Owens, who has lived with Parkinson's disease for decades. Owens herself, artistic and underweight, with no criminal record, was in a small detached guest casita with uncuttable screens. Nothing in the police paperwork indicates weapons, violence, or any threat to officer safety from anyone on the property. Measured against standard law enforcement practice, this was an extreme choice. Agencies, including Scottsdale PD in their own public materials, state that the tactical units are reserved for situations involving armed subjects, barricades, violent felonies, or imminent threats to life. None of those conditions appear anywhere in the reporting for this case. If investigators wanted documents, phones, or medical records, they could have obtained them through far less intrusive means. Perhaps a little daytime knock and talk, you know what I'm saying? A scheduled search so I can have ample time to falsify documents. A subpoena, deuces tecum. I don't know what the fuck that means. Or even simply requesting voluntary production. All are routine in white collar and family court adjacent investigations. And I put white collar in here so that you remember that I am rich and you are poor. So, just wondering if you remember that you're poor and I'm not. Instead, the county's most forceful option was chosen. And the consequences quickly left the justice system and entered the content economy. Ooh.
So you're not upset that you think they unjustly came into your house. You're more upset that it went into content? I'd be like, make this shit content all day. I'm suing the fucking police department for unjustly coming into my goddamn house. Are you kidding?
Body camera footage of the raid obtained through paid public records. Public records. Request crowdfunded by a Justice for Clayton, goddammit, you motherfuckers, creator shows the 16 officer staff in full tactical gear shouting, not me shouting on their body cam footage, but them shouting commands and threatening to breach the door. Deuces Taco, let's go. Drawing. When officers pull Owens into the hallway, pull her, she panics, swears, and pleads with them not to wake or drag her disabled father out of the bed, a man who she herself calls, quote, a handicap. An instinctive human reaction to armed men flooding your home before sunrise.
No, bitch, no, it's not. No, it is not. No, it is not. You know what my panic would make me do? Sit down and shut the fuck up. That's what my panic would do. I would sit down, I would put my hands up, I would shut the fuck up. If I had 18 people in my house with tactical gear, and let me tell you something, they would have to put me in handcuffs, because if my daughter was running around screaming and double finger blasting these officers and not shutting the fuck up, I would beat the fuck out of her. Are you kidding me? Oh. I need tacos. I need tacos.
The framing online has been anything but human. The footage was chopped into viral clips and reposted as commentary fodder for the same online community that had been demanding her indictment for months. Strangers debated her tone, her posture, her fear.
There was nothing about you that looked scared. Nothing. Nothing.
As though they were evaluating a reality show episode, not a real-world raid on a disabled woman's home. I am also a handicap. The videos then migrated to outlets like the Daily Mail and Inside Edition. Ew, everybody knows you go to the Sun, where a few chaotic seconds were turned into shorthand for her entire mental state.
Dude, they would have to tase me. If I was Jan and my daughter was Laura, they would have to pull their tasers. Because I would be like, shut the fuck up. Shut up. And then I would...
If Maricopa County has ever deployed a full tactical team in response to allegations rooted in paternity petition, it has not been advertised. I have not seen it. Have you guys seen it? There was no public record of any other family court litigant in a case with no violence, no weapons, no criminal history, and no ongoing threat being met with a 16-officer pre-dawn SWAT-style entry. The first indictment, making a scheme out of a mess. What the fuck is this music? On May 6, 2025, Mitchell's office issued a press release announcing that the grand jury had indicted Laura Michelle, I almost read Mitchell, Laura Mitchell Owens on 7 felony counts tied to what MCAO called a paternity scheme against Eckerd. According to that release and subsequent media coverage, investigators concluded that between May of 23 and June of 24, Owens altered an ultrasound image, fabricated a pregnancy video, and lied multiple times under oath. Where am I? According to that release and subsequent media coverage, investigators concluded that between May of... Oh, I already read this. Duh, stupid. If you only read the press release, you would never know that early clinic-run HCG tests are in the record. And it's also in the record that I bought HCG and could inject it myself, but I'm not putting that in here, you know? It's just a conflict of interest, and have not been alleged to be forged, or that the ultrasound image and video at the heart of this case was sent privately to Eckerd to just extort him and trick him into talking to me, not presented to the court as official exhibits. Although he sent them as exhibits. The public storyline is streamlined. Not a chaotic early pregnancy that went off the rails. Off the rails, God.
Hey, guys in the chat, can any of you tell me how your pregnancy stories went off the rails? Mine went off the rails when the kids came. So, there was that.
But a neat scheme slotted on the same page of MCAO's website as murderers, even though I have 2 babies that I claim to miscarried late, we can't find them, child predators, and road rage shooters. Can you believe it? Fraudulent schemes and artifices is the statute Arizona normally uses for big swindles, you know, for us rich people. People who loot the vulnerable. Like unsuspecting kind men who have never dealt with bullshit like mine. Rig contracts, like dating contracts that I put in emails for these men.
Really bad heartburn?
I did have bad heartburn. Or steal large sums through deception. Perjury is technically a class 4 felony, but in practice is almost never charged because the system would collapse if every fuzzy memory, exaggeration, or contradiction turned into its own criminal case. Thank you for that, Super Lyle. Ugh. That's not a defense bar talking point. Greg Woodnick, the Phoenix attorney who represented Eckert in the paternity case, and Greg Gillespie in a related civil litigation, has publicly said that in more than 25 years of practice in Arizona, he has, quote, never actually seen someone prosecuted for perjury. When the lawyer on the men's side of the aisle is stunned that perjury is being criminally charged at all, you're not looking at routine line drawing. You're looking at an outlier.
Yeah, because people don't fucking do this, Laura. They don't do this. Zaddy shout out. Right, so that should tell you how bad this is. Oh my... How much more do I have to go? Oh, you gotta fucking be kidding me. I don't know if I'm gonna fucking get through this. Are you joking? I better start reading. Yeah, I saw that she filed that.
Yet in this case, perjury is suddenly center stage. I should be center stage. I'm the star. I'm the Mary. You're the Rhoda. Between the Eckert indictment and the later superseding indictment, Owens now faces 5 separate perjury counts, each one carrying the potential for years in prison if staffed harshly, and 2 Class 2 fraud schemes counts on top of that. Speed read the highlights, good lord. Oppress, alright.
No, I'm gonna have to go pick up my fucking kid. I gotta eat lunch. God damn. A press release written like a reality show recap. When the subject is a violent crime, the headline focuses on the act, not the accused. Father indicted for death of 5-year-old daughter. Road rage shooter indicted. Domestic abuser sentenced to life in prison for murder. Okay, so what was yours? Laura Owens indicted on fraud charges. Okay. You wanted to be the public person. I'm the Romy, you're the Michelle. It's only fair that A hates itself. Oh my god. Oh, here's a Bachelor mention. Clang. Clang. Since Rachel Mitchell was sworn in on January 26th of 2025, not a single other press release reviewed from her administration has been used. Individual defendants... Oh, shut up. Even in cases involving a child's death, sexual exploitation of minors, or serious violence, there is no double announcement treatment. Hey, did you know that you can't, they can't put the kids' names in there? So, I don't know. Is she going through? I think so. I think so. I think so, at least. She's helping your SEO. What's the beef, girl? Stop it, Bruce. There will not be one. The second-hand indictment, rewriting the Gillespie story. Gillespie is a second victim of false pregnancy claim. If you stop reading there, you would never know, that she brought alleging abortion coercion and related claims. Okay, great. None of that context appears. Yeah, you brought that case against him. That doesn't mean anything. Criminalizing private drama and catfishing. Oh my God. One of the more striking features of the superseding indictment is how much of the alleged wrongdoing appears to involve private communications document. Yeah, they do that. They do that in criminal cases. They search through all of your shit. That raises a hard question. If sending embellished or misleading documents to a romantic partner is now identity theft, forgery, or fraudulent schemes, where exactly is the line? Catfishing. People misrepresent themselves online to romantic targets using altered images, invented jobs, or fake medical stories is hardly rare. I'm sorry, are you admitting this? People misrepresenting themselves online to romantic targets using altered images, invented jobs, or fake medical stories is hardly rare. You put that in here? Willingly? You said that? That was a choice. It is ugly and often cruel, unlike me, because I'm very beautiful. But Arizona has not historically treated every manipulative dating lie as a felony, much less a Class 2 fraud scheme. The real difference is who the target is and how much public energy is available to reward prosecution. Paternity law was never meant to be a felony trap. Right. Other people suck, so please don't prosecute me, okay? Oh my God, I don't care about this. Perjury and who it gets used on. Everyone understands the uncomfortable reality. Witnesses fudge things constantly. They overstate, minimize, misremember dates. This wasn't about misremembered. Oh, fuck. No logic. No logic. Judges issue blistering credibility findings. Lawyer use contradictions to win cases, and then the parties go home. Perjury charges are almost never layered on top because if every bad answer under oath spawned its own criminal file, the entire system would choke. That's what makes Owens an outlier. Out of the tens of thousands of criminal prosecutions Maricopa County brings each year, the person now facing 5 separate perjury felonies is not a cartel witness, a corrupt official, or a mob lieutenant. It is a disabled woman in 2 failed relationships whose behavior, whatever you think of it, played out in the overlap between family court and online spec. This isn't written by Laura Owens. There was no way she would ever put up this sentence. There's no way. She would be like a beautiful disabled woman who had 2 people treat her, abuse her, whatever you think of it. She would never put this. When the only time a statute gets dusted off is for the defendant who comes pre-packaged as an internet villain with a famous man on the other side of the V that isn't neutral enforcement, that is selective deployment of the harshest tools on the one person is okay. Who is this? Own up. Own up. Who is this? I need to know. I need to know who this is. Bye, Melon. Guilty as charged, right? Ugh. If you change his name, the case vanishes. Right. Which is why you bit off more than you could chew. Now to compare this case, no, we're not comparing. You can't compete where you don't compare, baby. What public safety risk exactly? To not do this to other men. If you or someone you love has been a victim of a shooting, a sexual assault, a serious domestic violence attack, or a random stabbing in a parking lot, you are entitled to be furious that this is where so much prosecutorial energy is going. Yeah, and if all these people can't get the resources that they need because you're out here just fucking sucking them up in the goddamn court system, they should also be mad. Arizona's public records laws give citizen the right to ask for the price tag. God. Wait, who's Hey Rob? Oh. Got it. And on a more basic level, there's a gut check question for any Arizona resident. If you had to choose who you might encounter alone in an alley, Phoenix at night, good Lord. You can't just compare these things. There is another audience for this case. Anyone in Arizona considering whether to step in a courtroom at all. Exactly. Because people like you sucking up the resources for actual victims and having people out here asking for more proof because you're such a fucking liar. Yeah, that's why they don't want to step in there. If making inconsistent statements about pregnancy timing, systems, and evidence in the middle of a chaotic breakup can be relabeled fraudulent schemes and artifices and 5 counts of perjury, then every litigant in high conflict family case has a reason to be afraid. Not if they can prove it. Not if they can prove it. Historically, the system has handled that with sanctions, fee awards, and sharp paragraphs in judicial rulings. Yeah, they tried that too. She didn't ask for a payout. He got a redemption tour. She almost gets it. She almost gets it. Right. Hey, you want to know what I just learned, Jack, actually? So there's a lot of theories in, there was a lot of theory in the course that I just took about the fundamentals of criminology and criminal justice. And they were talking about all the different theories, like how they figure out, how they study crime, and then how that helps the criminal justice system. And one of the theories is the deterrent theory, and it's about prosecuting someone and making a spectacle of them so that other people don't do this thing. So, that's one of the things that they do so that other people don't do it. But it's one of the theories. So, yeah, and you haven't paid up also, right? Right, people are supposed to be afraid of committing the crime. Right, but that's the thing. I just remembered that from my thing. It's called the deterrent theory. I feel smart. 90, I know, Auntie M. I know. It's supposed to be 8:45 tomorrow morning. We'll see, though. She filed for a motion. It doesn't mean that they're going to get it. So we don't know. We'll see tomorrow. We don't know that it's granted. There is also something quietly backward about who has gained from all of this, because it should have been me. Whatever you think of her motive, she was not seeking a headline-grabbing windfall. She wasn't? She wasn't? Which is why she went to the Sun? What Mitchell's legacy will be. Putting you behind bars, I think, pretty great. All right. I'm done with this bullshit for today. Ugh. Oy. Oy. All right, listen. I can't read any more of that bullshit. My brain is fried. What are we covering next? Landmark case. Tomatoes, tomatoes, tomatoes. Good point. Yeah, I don't know why that's not working. All right, let's go to Volo and see what we can start working on. What do you guys want to break down piece by piece? Do you want to do, we can do other victims. We can move on to Clayton. We can do one of the shorter ones, which is like any of the other things that she has. We can go through let's see. That's the overview. Do any one of these. What do you guys want to cover next? No, I don't mind it. It doesn't bother me. I don't mind it. I just want to know where we're going on the Volo website. What do you guys want? You tell me. The businesses. Tomorrow we can cover the case of Lowe versus the flute. More art. All right. What are the businesses? This section is being developed. Thank you for your patience. Laura Owens had co-owned several businesses. All right. So that's just this. I'm here for all of it. All right. What have we covered so far? Just so I can keep track of that. We've covered in full. Because some of them I don't want to have to go back. I know we did the ADRE hearing. It was a shorty. Okay. Sometimes we're here for Bacon Bearzz. Sometimes. All right. So we've covered. Let's see. Greg. Michael. I know we haven't covered like Dave or anything like that. Oh, there's Sweetnam. What's Sweetnam Enterprises? And number 13? All right. Well, we can cover that tomorrow. All right. We'll go over the short ones tomorrow. Alter egos and sock accounts. We'll do that. All right. So tomorrow we'll cover businesses. And then we'll go over number 13. So we'll knock these out of the way. I know that I've covered some other ones, so I don't want to have to go through those again. We have the Ron and Jan court cases, Frosted Flakes' entire career. Oh, God. All right. We'll start doing... Did we cover her videos with Gingy? Not all of them. All right. So we'll do... Let's see. What do we got? All right. Tomorrow we'll do businesses. And then we'll get into like bankruptcy stuff, or not bankruptcy. I'm sorry. The businesses. And then also like the other businesses that she's had, things with, like the horse thing. Yeah. History of legal disputes and pregnancy claims. So, okay. We can get into this too. But I was talking more about, Sean Rowan Horse, PS Creative. Like, we can get into those businesses because those are a little shorter as well. So, Uber. I got to cover Uber. Lone Cactus. I got to cover that. So, we got to get into all of this. So, all right. We'll start there tomorrow. I am tired. I need some lunch. Okay, if you guys are new here and you are not subscribed, please consider doing so. I go live every day. I will go live every day when my kids go back to school. We are covering this case in depth. I'm diving to the bottoms of hell. And yes, we will have... the reaction to the 341 audio is the second half of yesterday's video. Somebody, I believe, timestamped it. So we will do that. I think her name is Sassy and Fun. Okay. We can get into all of that tomorrow. I will be having marathons this week because my kids are at camp. It will be great. I am spent. Hit the like button. Make sure that you guys subscribe or hype or whatever. Leave a comment down below. And it helps us engage with all of the algorithm stuff. This was a lot today. You know what? I'm happy to be done with Michael Maricini. And I got to tell you, he's probably happy with me to be done with him as well. And he doesn't have his face on thumbnails all over the internet. I might have to change those eventually. But anyways, I love you guys. I will see you guys. Oh, I'm marathoning the rest of this week, homie. We're here. Get ready for it. So 20K by 2027. Let's go. Yeah, make sure you share everything. Let's go. And I will see you guys tomorrow. Bye-bye.